Start with a little OB cam to get you guys going. Alright, that doesn't want to work. That's fine. I'll be over in just a minute. I gotta get okay. We got our audio. Hamm v. Smith. And FS Credit v. FS. Okay, won't let me do that many letters. All right, cool. We'll just go. There's that one. You gotta connect. Sorry guys, I gotta go through and connect all of my little toys now. Make sure everything's hooked up. Hey Benny. No audio is coming through for some reason. Hello? It looks like it's coming through. Maybe it just said it. People in TikTok, if you can hear me, please let me know. Thank you, Betharoni. Can you hear me okay, Betharoni? Testing, testing. All right, you're good. That's working. That's working. Now, knock on metal here. Oh, I can switch over now. I'm here. Where are we? Let's switch here over to me, shall we? Hi there. How's everybody doing? Let's adjust that camera a little. Get me in the shot. There you go. So I am optimistic that I fixed the audio problem from yesterday. And I have two different options. So if one is tripping out, well, might be able to try another, although now the other one's acting weird, but whatever. Fingers crossed. I did something different and I'm hoping that it worked. If it doesn't work, then for January, which is the next one, I will bring out the nuclear option, which is a totally new one. Is somebody, let's see here, did anybody on TikTok tell me they can hear me? That would make me feel better. Morning, Robin. How are ya? Okay, we are at 9:59. I'm actually going to go back to, oh. I don't trust their website, their audio feed. Let's see. It is still connecting me, even though it's 10 a.m., it's still connecting me to something that says Tuesday, like yesterday's feed, and then it runs for 12 seconds and stops. So, okay, good. I'm glad you guys can hear me okay. There we go. Now we're at Wednesday, and in theory, we are live. Let me make sure that my audio is set up properly so I'll be able to hear them. Oh, all right. And this text in the corner is working for YouTube, so you guys should be able to see what everybody in TikTok is saying. It is a little bit over. I'll work on how it's kind of overlapped a little bit later. I can only, once I put it in, it's kind of stuck there. But I thought that would be a really useful thing because there's so many people talking. It's good you can hear me all the way in South America. I would like, there is a way for me to do the same thing for you TikTok guys so that you can see what the YouTube people are saying. The problem is that there is no way for me to remove the text feed from the screen, and it takes up such a big chunk of what's already a small screen that I didn't want to take up another chunk of the screen with what would essentially be a duplicate of the chat that you're already seeing. So until I figure out a workaround, which you never know, this is where we are. This is what I'm doing. Okay, so we're waiting to hear. I'm going to give them a minute. Usually they start a minute or two late. Just a quick reminder, we have two cases this morning. One is a little sad. One is a, I'm going to keep saying I'm going to keep trying to say capital punishment case because, you know, I'm going to get in trouble if I use anything more problematic than that. And this is related to Article or Amendment 8, the 8th Amendment of the U.S. Constitution, which says that we can't have cruel and unusual punishment, right? Yeah, cruel and unusual punishment. And it's been determined that cruel and unusual punishment includes giving capital punishment to somebody with an extremely low IQ. And there's a case called Atkins v. Virginia, I think. Watkins v. Virginia. Atkins v. Virginia. I think I may have said it wrong in the video, but whatever. Atkins, Watkins, something like that. That kind of set a number at, hey, Jellicali, how you doing? And Margot, rather. It set the number at 70. The IQ of 70 is kind of the cutoff. And the problem is that this guy got 5 tests. All of them were above 70. Some of them were well above 70. They went up to 78. But one of them was a 72 plus or minus 3, which says he could have an IQ of 70 or below. And the question is, how do we deal with that? Alabama says they should overturn this, let them do what they do in Alabama, because all of his official scores are above 70. I'm going to go ahead and relaunch the Supreme Court audio because it's a couple of minutes later than I'd like. And sometimes you have to relaunch it. So just want to make sure they haven't started and it didn't just freeze on me or something.
I mean, first this morning in case 24-872, Hamm versus Smith.
Can everybody hear that okay?
Mr. Overing?
Mr. Chief Justice, and may it please the Court. Nothing in the 8th Amendment bars the sentence Joseph Smith received for murdering Dirk Van Dam nearly 30 years ago. Atkins created an exception for offenders known to be intellectually disabled, but Smith is not. He didn't come close to proving an IQ of 70 or below with scores of 75, 74, 72, 78, and 74. But the lower courts changed the rules. First, misreading Hall, they took the lowest score to represent a possibility that Smith's IQ is 69. Then, to the extent they considered other scores, they took each only in isolation and moved the line to 75. These maneuvers expanded Atkins, and this court should reverse that expansion. First, because it was not authorized by the 8th Amendment. Second, because it would eliminate state discretion. And third, because it ignores that the combined effect of multiple IQ scores reduces error and yields a more accurate estimate. The answer to whether courts may consider the cumulative effect of multiple IQ scores is yes. The answer to how they handle multiple scores is not found in the Eighth Amendment and thus left to state discretion. Still, this court can offer some meaningful ground rules for how to handle multiple scores. First, states are allowed to make the first prong turn on the very best evidence of intellectual functioning, IQ. Second, states are allowed to define the requisite intellectual functioning as an IQ of 70 or below. Third, states are allowed to require the claimant to prove his IQ by a preponderance of the evidence. The court can then supply a durable rule of decision by which a state can adopt a reasonably reliable method for handling multiple IQ scores that when it suggests the offender's IQ is greater than 70, his sentence does not violate Atkins. Here, every identified method of handling multiple IQ scores favors the conclusion that Smith is not intellectually disabled. I welcome the court's questions.
How would you specifically handle the multiple scores here?
In this case, the consistent evidence is that Smith's IQ is above 70, and we've offered 5 different ways to see that, but we think ultimately it's Smith's burden to come with a method that proves that his IQ is likely below 70.
So what did is the test whether or not it is likely or is?
Likely below 70 is our understanding of the preponderance burden in Alabama. Other states are free to adopt other burdens of proof.
And what was the finding of the Court of Appeals and the District Court?
The sentence, Smith's IQ is below 70, doesn't appear in the District Court's opinion nor in the Court of Appeals' opinion. They found the first prong satisfied by a preponderance of evidence, but only after they changed the standard to be not just intellectual functioning, but not just IQ, but a broader conception of intellectual functioning.
What if the scores were 69, 68, 69, 69, 75? I mean, would you concede in that case that it was the actual IQ is below 70, or would you still argue, well, 75 is above, so we're going to look at all sorts of other things?
Well, the burden would still be on the offender to prove a likelihood that his IQ is 70 or below, and so he'd have to come with a method. Here, Smith didn't.
He'd have to come with a what?
With a method for assessing those scores. Here, Smith didn't, so his claim fails. We have an argument that the highest score should be given more probative weight because there are many ways that an IQ test can underestimate IQ.
Doesn't it feel like when it's your life, it shouldn't be the burden on you to protect it?
To avoid the death penalty.
Well, it does see, you can see why that might be regarded as a little results-oriented. When you have scores above 70, you want to average them and discount the one below. But when they're all below, you don't do that. You instead say you got to look at all these other factors.
It's not results-oriented, Your Honor, because there is a scientific warrant behind it. And we have to think about what IQ tests are doing. They're trying to measure the capacity for intellectual performance. And so someone's best score is the best representation
But
of their
Mr.
best.
Overing, it seems to me that you are actually changing the standard. You've accused the district court and the Court of Appeals of doing so, but in our case law, consistently, we've said that the first prong relates to a showing of significant sub-average general intellectual functioning. The words IQ score under 70 does not appear. Though that's not the standard. I appreciate that that's one of the ways in which science has determined that you can make such a showing, but we also have allowed for evidence related to adaptive functioning to be taken into account when looking at intellectual functioning. So I think what you've done is shift this to be all about the IQ test in a way that is not supported by our case law.
Atkins cited the 4th edition of the DSM, and I think the phrase that you just used appears in that edition. And then further defines what general intellectual functioning means. And it used to mean an IQ of 70 or below. Before that, it was 65. Now they're saying it's 75. But IQ has always been the primary criterion by which intellectual...
Primary, but not the sole. And we've never said it's been the sole. And what the district court did here was look not only at the IQ scores holistically, but also other evidence of adaptive functioning. And that's precisely what our case law says that the courts are supposed to do. So let me ask you, why do you think that the test should be simply and solely IQ score cut off at 70?
There we go.
IQ is originally how intellectual disability was defined as a condition, and it's always been the primary criterion, and states are allowed to take the best evidence of intelligence and to make that the test.
But what do we do with the brief of the American Association of Intellectual and Developmental Disabilities, the actual experts in this area, who say, and I'm looking on page 24 here, other than requiring the careful use of clinical judgment and professional responsibility in performing a complete analysis, there can be no single mandatory empirical method for clinicians to use in considering multiple scores or in determining whether or not someone is intellectually disabled. They look at a lot of things. So reducing this to a single score seems to me misguided.
Well, if there can be no one mandatory method, then it's up for states and their legislatures to decide. That brief also said on page 15 that IQ remains the best single representation of intellectual functioning. And the alternative is very unworkable. Courts do not have a means by which they can compare the evidence at prong 2, for example, that he struggles with navigating the subway system or doesn't know how to cook certain dishes against the objective IQ evidence. How many points?
I'm sorry. I'm having a really hard time with this case because I don't think you're wrong. States can define this the way they want. The problem here is not what the state of Alabama is doing. The Alabama state is doing what all courts are doing. You haven't pointed me to Perkins or any other court where the rule that you're proposing has been adopted by Alabama. When we get that case, we might answer your question, but in the abstract, I don't know how we can answer it here. You didn't argue this below. Your own expert did exactly what you say
Sotomayor is big on stare
is
decisis.
wrong. Your own expert said he had valid scores between 72 and 78, and he relied on all of the other indicia to determine that he believed this person wasn't intellectually disabled. Respondents' experts concluded differently, and the district court credited respondents' experts. But please point me to somewhere in the record in the district court where you made this argument. In 2015, the 11th Circuit, not the order before us, determined that the Alabama courts had erred unreasonably because they had done exactly what Hall told them they couldn't do. They looked at the 3 scores that were extant at the time, 72, I think it was 72 and 274s or something like that. It wasn't the 78. The 78 came later. And they said, on the basis of those scores alone, he wasn't intellectually disabled. And that's exactly what Hall, the year before, had said was wrong to do. You didn't appeal that decision, so we have to accept that the district court is now the finder of fact. And if the district court is the finder of fact, it can do exactly what you're saying. Follow Alabama law and show me one case in Alabama that has followed your rule. Tell me where in the trial record you argued that somehow aggregating scores, that somehow medium scores, that somehow there was one perfect IQ score that states could require. Just show it to me. point me to the record.
Respectfully, Your Honor, at the start of your question, you asked, what is Alabama law? And I say Perkins says it's an IQ of 70 or below. And you implied that
But
that's...
how do you prove that? In Alabama, courts do exactly what the district court does
I think
here.
this is the answer to your question,
It looks
Robin.
at the SEMS. That's what the court did here.
We've set up a
It then decides whether the
standard.
person is within the range of intellectual disability, which the court did here. The SEMS certainly are at least 3 out of the 5 are within disability. And then it looks to other things to determine whether the person's intellectually disabled. It's exactly what we told people to do in Hall. It's exactly what we told people to do in Moore. What you're asking us to do is to undo those cases, because both in Hall and in Moore, there were various scores, just like in this case. In Hall, there were 9 scores between, what were the figures? 9 scores between, I can't remember now.
71 and above.
Not much, even worse than here, between 71 and 80. Here, there are 5 scores between 72 and 1 score of 78. And in Hall, only 1 of the lowest scores fell within SEM.
So
And here, there were 3.
I'd like to clarify first Alabama law, because in Your Honor's own description of what the state courts did in this case, they relied on the scores of 72, 74, and 75. And now they have Hall.
Without looking at the SEM. And we, in Hall, the year before, said, you have to look at the SEM. And they didn't.
We've cited multiple Alabama cases, Bush, Byrd, and Kalin, all of which had similar scores to Smith's here.
If you read every one of those cases, the courts there did exactly what this court did here. They looked at all of those scores, then they looked at the adaptive functioning to determine whether the person was actually at the lower end of the score or the higher end of the score.
State courts have...
Can you dispute that that's what those courts did?
In some cases, the courts do look to other evidence, but they don't grant an Atkins claim based on that other evidence. There's not an Alabama case in which an offender was known to have an IQ above 70 and yet won his Atkins claim. And there's certainly not an Alabama case in which the courts plucked the lowest score alone and said that represents a possibility of intellectual deficits and moved on.
That's not what happened here.
That's my question, counsel. I wanted to know about the Alabama law, too. Could you just precisely explain, I don't want to delve into the record in this case, so my question is a little bit different from Justice Sotomayor's. I just want to know what is the Alabama rule, because it seems to me that Justice Sotomayor is right that there are some Alabama cases that do move on to adaptive functioning, and so what about the other indicia, and what role do they play in Alabama law?
I think since Hall, courts have been confused in Alabama and nationwide about what some of the dicta in Hall means. I mean, with all due respect to this court, there are some confusing lines in Hall to interpret and apply in these cases with multiple scores, if Hall applies at all to cases with multiple scores. And so the Alabama courts are grappling with that too, and they say, well, we looked at everything. We looked at the whole record, but there is not a case in which that other evidence has ever trumped IQ in Alabama. And what Alabama wants to do is best exemplified by its pre-Hall case law, such as Ex parte Smith, in which a 72 seriously undermined the Atkins.
For Alabama.
But I'm confused because it doesn't seem like Alabama
yes. You're correct,
prohibits
Jessica.
the court from going on. So if a federal court is trying to figure out what the Alabama law is, wouldn't a federal court be justified, say, if we remanded it to the 11th Circuit in considering factors beyond the IQ scores?
Well, I think the best evidence of what Alabama law is how the courts applied it in this case. I think at the end of the day, this court has to determine what is the federal constitutional minimum, what's the floor for Atkins claims.
Counsel, I mean, with respect to Alabama and its law, whatever it may or may not be, can a federal habeas court grant relief without finding a violation of federal law or the federal Constitution, in this case, the 8th Amendment?
No. And that matters quite a lot.
So what matters is he intellectually disabled? That's the federal law, right?
The federal law is Atkins and Hall.
Exactly. that you can't execute an intellectually disabled person.
What is your understanding of the role of state law in making that determination, whether Atkins and Hall leave discretion to Alabama in defining what intellectually disabled is? That's my question. Obviously, it's an Eighth Amendment question, but what is the relationship between the Eighth Amendment and state law on this question?
So for Atkins, page 317, said that to the extent there's disagreement, the states have disagreements about who qualifies, who is in fact intellectually disabled. And so there's some suggestion in Smith's brief that the state's discretion extends only to procedural or evidentiary matters, but I read that paragraph in Atkins to mean that states actually have leeway as well in defining intellectual disability. And the definitions change. One reason states need discretion is that the line used to be 67. AAMR at one point put the line at 85. Now it's 70, or maybe it's 75 or somewhat above 75. And so states are not required to divine from these different psychiatric manuals what the best possible science could be when they're making a legal determination of intellectual disability.
Let me posit this to you, that Atkins was trying to give states a little leeway
Never tell Robertson a legal
because
part.
Atkins was it was a strong new holding
Carrie,
from
I
this
think
court, plowing new
Carol,
ground,
I think
and
you might be
tried to give states some leeway. But at the end of the day, a federal habeas court cannot grant relief on the basis of a violation of state law.
Correct. States can be more lenient, but that would not be a ground for federal habeas relief.
You
Smith
have
has
to
an
find
Atkins
that
claim.
there is an actual Eighth Amendment violation in this case.
Correct. Smith has an Atkins claim, not a Perkins claim, and Alabama is not more lenient than Atkins. Alabama is not more lenient than Hall. Alabama is trying to enforce the
It
constitutional.
would be rather surprising to hear Alabama come in here and say we're more lenient
Correct.
than what the court is requiring us to do.
Robin.
Absolutely.
It could happen, but it seems unlikely.
Not in this case.
And under Atkins, what do you think about? Because I'm sorry, my time's expired.
No, please continue.
You're asking about what the Eighth Amendment. What do we do with our precedents in this area? What if we said under Atkins, states can implement prong one however they want, because that's what Atkins says, as long as they don't treat a single score in the low 70s as decisive, Hall, and two, don't use extraneous facts to IQ scores to outweigh a low score more.
I think that's correct with one caveat. It's not just a low score in the low 70s, but it has to be a score that has an error range, and that could be one standard error of measurement, according to the APA's brief in Hall on page 23, that includes 70 within its span. So that's how I would read Hall, but yes, those two rules are how we read the precedents.
Thank you.
Thank you, counsel. Justice
There are
Thomas?
three reasons to punish people, guys. Deterrence is one of them. So deterring people is one of them, but revenge is also one of
I
the
don't
theories.
see
It may not be a
any
good one,
state
but you have to keep that in your
that
mind.
defines
So that does justify this for
intellectual
some people.
disability this way. I certainly don't see, or to prove it this way, I don't see anything in Alabama's law that suggests it's following that rule. You're making something wholesale up, and you're claiming that there's disagreement in the lower courts. I don't see all
Retributive
that much
is the name of it.
disagreement.
Retribution.
In Smith's table on page 17 of the appendix, he has cases from across all the states. And although you try to reap some confusion among them, they all seem to be following the method the district court here followed.
Should is a...
And we announce a new rule. We've announced more confusion into an area
Tap your
where
screens,
there's
guys. We're
pretty
low today.
standard procedures.
Tap
They
and
do
share and all that
exactly
stuff.
what the district court did here. I have no case that I have found, and I want you to find one state case that applies the rule as you've articulated it.
Oh.
Byrd versus State
Okay.
clearly states that the offender has the burden to prove by a preponderance of the evidence that his IQ is 70 or below.
There is no dispute about that. Assume I take that as a given. We didn't grant cert on that. because that really wasn't disputed anywhere. So where's the rest of what you're saying? That states determine prong one based solely on IQ scores and some statistical unknown method of creating a medium composite score.
There are different methods. Some state courts have taken the average or the median, or they've simply said the scores are consistently above 70, and so it's an offender's burden to come back and overcome that with a statistical method. It's not Alabama's burden.
Tell me name one court that has held that it's up to the defendant to prove the first prong by a preponderance of the evidence with some statistical measure. It's not what I see. I have not found one state case that has required that. And now you're going to put in a new requirement that's actually even more complex than what states have been doing.
Well, Hall itself said that evaluating multiple scores is a complicated endeavor. Experts
I am asking you for a simple answer. Name one state case that has made your prong one dependent on a statistical analysis of what somehow either an aggregated, medium, composite, I don't care what word you use, one state case that has required that.
Well, I think courts haven't needed to go that far because offenders haven't come with a method. They haven't satisfied their burden in these cases.
But they have granted relief to others without it.
Not in Alabama. Sometimes the 11th Circuit will do that, applying this lowest score rule, and there is a division of authority. The 8th, 9th, and 11th Circuits look at the lowest score alone and say that it represents...
They may well be wrong, and I think they probably... I haven't looked at those cases carefully enough to say whether they made error or whether you're characterizing them in a way that's not quite accurate, like here. The 11th Circuit made clear, as did the district court, that it wasn't relying on just the one law score. There were 3 scores that were within the SEM of 70 and below.
Hall said that IQ is a measurement that has statistical properties which we can evaluate, and that's why we take into account the standard error of measurement. The experts in this case are also telling us...
one case that has required plaintiffs to come in with the statistical mathematical certainty of a particular number.
Not certainty, but a preponderance of the evidence.
Thank you, counsel. Your answer must be
Justice Kagan?
Nope.
Mr. Overend, I guess when I read Hall and Moore, I come away with a couple of things that are relevant here, and then a lot of space for the state court to do what it wishes, including with respect to multiple scores. But here are the 2 things that I take from Hall and Moore that are relevant here. The first is that in looking at any given score, you have to take into account the standard error of measurement, right? So that a 72 with a standard error of measurement of 5 becomes a 67 to a 77. And that's one thing that they said, right? You can't just treat it as above 70 because you have to recognize that SEM. I don't think you disagree with that.
Except for the 5. Correct. Courts have to take into account standard error, but it's not always 5.
Of course. I'm just using that as a hypothetical. All right?
Yes.
Kagan.
The second thing that it seems to me come out of those 2 cases is when you have a score, and most of these cases you're going to have, almost all of them, you're going to have multiple scores. But when you have one score, because in both of these cases they just treated that low score as dipping below the 70 or a 70 below, that gives the defendant the opportunity to come forward with adaptive functioning evidence. It's just an opportunity to come forward with that evidence. Now, at that point, and this is true of a state that does the whole thing holistically, it's also true of a state that breaks it up into prongs. At that point, a court can decide how that evidence compares to all the other evidence in the case. And if it's a multiple score case, where it's only one score that's dipping below 70, of course, the court can say, you know, there are 5 other scores that are above 70, and we think that that's highly probative. So, you know, it's very nice that he had the chance to come in with adaptive evidence, but that's not going to play in our analysis because we look at all the scores, and the scores alone do it for us. I think a court is definitely allowed to say that after Hall and Moore, as long as they've given a person the opportunity to come in with adaptive evidence. But they're also allowed to take into account that there are a lot of scores that suggest that the person is not intellectually disabled. So that's what it seems to me the law is coming out of these 2 cases. Do you agree with that, or do you not agree with that?
No, I don't agree with that because Hall didn't answer the question of what to do with multiple scores. And so if it's...
It didn't. I mean, and because it didn't, that's why I say it really does leave a lot of discretion to a state court to decide how it wants to deal with the fact that there are a lot of scores on the plus 70 side and not a lot on the minus 70 side. That's totally within a state court's discretion to say there are a lot of scores here on the plus 70 side. That's dispositive for us. As long as they've given a person, this is the only requirement, it seems to me, that comes out of Hall and Moore. They have to give the person with the 70 or minus score the opportunity to come in with adaptive evidence suggesting the opposite.
Well, that would be an extension of Hall, and we've said that Hall should not be extended.
I would have thought that that's just what it says.
If it's reasonable for a court to do that on a set of facts, then it should also be reasonable for a state legislature to say the true IQ line is 70, and that can be dispositive. So if a court could do that with scores of 72, 75, 76, why couldn't a legislature do the same thing and say, no, we don't want to leave that door open because we don't trust trial judges to do this well?
Yeah, but I think that is the difference, right? That Hall and Moore did say, you have to give the person the opportunity, you have to put it in front of the judge for the judge to say, you know, this is a case where I'm not convinced, you know, there are 5 scores, but they're all hovering around the 70 mark. You know, as compared to a case where there are 5 scores and most of them are nowhere near the 70 mark. So you have to give this person the opportunity, once you have that low score, to say maybe it's that low score that should be, that is more reflective of the person's intellectual function.
Covering for you.
There's more we can do with IQ, and the experts are coming in and agree with us that there are ways that you can combine the scores. And so the offender's at least got to do that and at least has to show a likelihood below 70. If there's a case where it's truly indeterminate, and that's what Hall seemed to think, that a score of 71 is so uncertain standing alone, if there were a case that's truly indeterminate, then perhaps there could be other evidence of intellectual functioning, not adaptive behavior, certainly.
I don't think that they thought it was indeterminate standing alone. I mean, both Hall and Moore are multiple score cases, and both were perfectly aware that they were multiple score cases and talked, as you said, about the difficulties of dealing with multiple scores. So they knew that they were talking about multiple score cases. And the requirement that they set up is still, if you have one score that brings you into the 70 minus range, that's enough so that you have to you have to open the door to a person's evidence. Now, that's not to say you have to accept that evidence for a moment if there are a whole bunch of scores going the opposite way.
But we know what happens in these cases is that courts don't weigh the IQ evidence. They don't say, well, the IQ evidence is really strong for the state. Let me weigh that against his inability to buy car insurance or to maintain a bank account or something like that. They simply move on from IQ. And so once you open the door to this kind of balancing test, the second prong is really malleable, really amorphous, and we're picking up disparate facts about someone's life, self-reported or by biased reporters. And so that evidence is not disciplining the inquiry. It's not adding more rigor to figuring out what the intelligence is. And if it were, then the IQ specialists would simply make a better IQ test that accounts for things like that.
Okay, thank you.
Justice Gorsuch? Justice Kavanaugh?
So what are the different permissible Eighth Amendment approaches a state can use when there are multiple scores? For example, in your reply brief, you articulate if the median is above 70. Is that, if the median's above 70, can the state say that's it?
Yes.
Okay. And you don't think Hall and Moore require more analysis in those cases? You think that's a safe harbor, so to speak?
Tap your
Yes,
screens and
states
hit
can
like
adopt
and all that stuff,
reasonably
guys.
reliable methods, and the APA handbook says that the median is option 1.
Okay, and if the another approach you articulate is the overlap approach, the overlap among each score's error range, same question there. If the overlap, you're a little bit ambiguous about what the overlap needs to be to give you certainty. What, you want to explain that? I know you think it's satisfied here, but what's the rule?
So the idea is that when there's a cluster of scores, that we can take into account each score's error range and then lay them on top of each other and see which numbers the error ranges have in common. So the intuition there is that maybe his true IQ is somewhere in the middle.
What if the bottom of the error range is 69 or 70?
Hey, thanks, Penelope.
Of the overlap error range?
I don't think that's a problem for the state, because the question is still the likelihood that his IQ is 70 or below. So simply having the number 69 in an error range, whether using the overlap or some other method, doesn't reflect a greater than 50% chance that his IQ is below 70.
But in any event, in this case, you say the bottom of the overlap is 73, I believe, correct?
He says hi. He says
At least
thank you.
that's what you say in the reply brief. You say 73 to 77.
And I think that should be a 78, but that's on the most generous assumption about the error range being plus or minus 5.
Okay, and is the composite score method another method that the state can use, and in your view,
Who knows what's good,
stop
Manny?
there?
Yes,
Yes.
when it's available.
And are there any other methods?
The average is a rough approximation of the composite score.
Well, there's a lot of skepticism about the average being accurate.
Well, the author of the one of the authors of the APA's amicus brief in this case, Dr. Schneider, said that the average is a rough approximation of the composite score. Even if the composite score is the theoretically best method, states are allowed to adopt other methods. The fifth method would be to look at the high score when the highest score's entire error range is over 70. And those are the 5 that we've discussed as reasonably reliable methods.
And why there, this picks up on the Chief Justice's question, but why are you picking just the high score in that fifth approach?
The highest,
it seems, as he said, result-oriented.
the highest score is more probative because there are many ways that an IQ score can err downward and very few ways that a score can err upward. And so especially to take into account the obvious incentive to malinger in these cases, the lowest scores should be viewed with greater suspicion. Oklahoma has adopted a rule like this and has withstood federal review for many years.
And follow up on Justice Kagan's question, what's the logic or the rationale or the sense behind not having a district court or a trial court or a state court have the ability in those circumstances to go on and look at more? Because I think what you are saying is each of those approaches are essentially a safe harbor. You win. The defendant can't meet his or her burden in those circumstances. You win. The state court can't go on and look at other things. That's, I think, what you're saying. What's the logic, the rationale, the sense behind that?
Well, the adaptive behavior prong is simply not as good as IQ. And so once you start weighing that subjective and amorphous evidence against the objective evidence of IQ, we don't think it's within courts' capacities to do that well. Even if clinicians could somehow weigh the evidence of the ability to buy groceries against the IQ score of 78, I don't know how courts would do that. Adaptive behavior was added later. Originally, the diagnosis was just based on IQ. There's great disagreement among the experts about what adaptive behavior even means.
Yeah.
Is it 10 or 11 domains or 3 different domains? And there's great disagreement about how to even measure it. There are hundreds of different scales, inventories, batteries for adaptive behavior. I think people have a misconception that these are just other standardized tests, but often it's not, and there's a lot of judgment that goes into picking them. So I'll just give one example in this case, a reading comprehension test. The courts below credited evidence that that Mr. Smith is barely literate, I think at Petition Appendix 22, and then he was administered a reading comprehension test that showed he reads at an 11th grade level, which is clearly inconsistent with intellectual disability, but the state courts focus on the evidence from grade school, they pluck out a different fact, and so this is not a really rigorous scientific test. The way that IQ is the fruit of a multi-century enterprise to figure out the best possible estimate of intelligence.
Thank you.
Justice Barrett, Justice Jackson?
So I guess I'm trying to understand the basis for our being able to determine that the district court in this case erred, which is what I understand you to be asking us to do. So are you saying that Alabama has selected any one of those 5 methods by legislation, for example, and the district court refused to apply it in its consideration?
No, Alabama hasn't adopted one of those.
All right, so you explored a number of possibilities with Justice Kavanaugh, none of which Alabama has actually adopted, so we can't say that the district court erred by not applying Alabama law in that sense. Did you ask the district court to apply any of those methods in its consideration of this defendant's intellectual disability?
Well, it's the petitioner's burden to come in.
No. Did you? Your burden right now as petitioner is to establish that the district court erred. And so what I'm trying to ask you is whether you are saying that the district court erred by not evaluating this defendant in a way that he was never asked to do by the state below.
Well, it's a legal error because my answers to Justice Kavanaugh were that those are all reasonably reliable methods that the state could adopt, and if that's true, then it doesn't matter whether Alabama has in fact adopted them in statute because there's no Eighth Amendment violation.
That was my first question. Doesn't it matter for the purpose of our evaluation of the district court's error whether or not the district court was asked to evaluate this defendant using the method that you now say it was erroneous for the district court to not have used? I mean, this never came up during, like, no one said to the district court, please evaluate him using this method, and the district court said no. In that situation, we then assess whether the district court was wrong in refusing to adopt that method.
You didn't ask them to do it.
We didn't get that far because we had 5 IQ scores that clearly show he loses, and then the district court focused only on the 72.
But you didn't try.
And so the question—
The district court was weighing all of the evidence under the standard that it seems like your expert also agreed was the right legal test at the time. And now you're saying the test should have been different. The district court was only allowed to look at one of these other 5 reliable methods, although no one said to the district court at the time, please look at that method.
We said to the district court, Alabama law is a true IQ of 70 or below by a preponderance, and then the district court did not apply that burden.
Okay, let me ask you this, because I do think that there's something about party presentation here that's a little troublesome. A couple weeks ago, in a case called Clark versus Sweeney, we summarily reversed a grant of habeas because the Court of Appeals had granted habeas based on an argument that the petitioner had not presented. So I feel like you're actually asking us to violate that same principle. You never asked the Court of Appeals in this case, for example, to evaluate the district court on the basis of these 5 methods and say that it was erroneous on that basis or on the cumulative effects test. I'm a little confused all around, because I thought the question presented in this case was about the cumulative effects test, and that's what you were actually advocating for, but that didn't come up in the lower courts. So how could we possibly reverse on the basis of these kinds of arguments that were not presented below?
We absolutely did present evidence from Dr. King at JA 270 and 271 that his consistent scores were above 70. We didn't have to get to the level of granularity of specifying a particular method because there is no method in this case that can prove his IQ is likely 70 or below. We're offering those to answer the court's question how to assess multiple IQ scores,
and
but it's
your
sufficient
answer
to
is
reverse.
your answer is not something about cumulative effects is what the court had to do and didn't do. I thought that was the test that you were requiring us to consider as the thing that a district court has to do.
Our first argument is that it didn't do that because it looked at only at the possibility.
Maybe what's good.
And if the court agrees it has to do
Wait,
that.
I'm sorry. I just I thought you were saying the district court erred because it didn't consider the cumulative effect of multiple IQ scores, and that the cumulative effect was a thing that the district court didn't do. All I'm asking here is, did you ask the district court to do that? Or did you say to the Court of Appeals the district court has erred because it didn't look at the, quote, cumulative effect of the multiple IQ scores?
Yes, we said that in the district court with Dr. King's testimony. We said
cumulative effect. I'll find it in the record. Because I didn't see the words cumulative effect in the record.
Well, there are lots of synonyms, but consistent scores above 70, that's the same thing. And then the 11th Circuit, we presented this evidence and said the district court didn't take seriously the whole of the IQ evidence because it didn't even mention his score of 78. So it couldn't have done the cumulative effect. That's enough to reverse. If the court wants to go further and discuss the reasonably reliable methods, we think that would be a good idea, especially for guidance.
So you're not asking necessarily for that rule about the reasonably reliable methods that certainly did not come up before?
Well, that is the question presented, and so that would be a complete answer to Smith's claim, is that there is no way that he can prove an IQ below 70, because even on these common and expert-approved methods, he hasn't shown that his IQ is below 70.
Thank you.
Thank you, counsel.
Gotta be ready for those fly balls, guys. All right. So again, real quick, before the next one comes up. Okay, deterrence.
Mr. Chief
Retributive
Justice, and may it
theory
please the court.
and
Under
fixing people.
Atkins,
Those are the three
states have
theories
significant
that
discretion
we punish.
in defining what it means to be intellectually disabled and what a defendant must do to prove it. Alabama has exercised that discretion to require that respondents show his true IQ is likely 70 or below based on all relevant evidence, including his multiple IQ scores all above 70. The courts below erred because they replaced that burden with some variant of a one low score rule. Everyone now agrees that such a rule is wrong. Instead, respondent focuses on justifying the opinions below as applying a holistic analysis, but that misses the point. The problem here is not that the courts below simply looked at other evidence. It is that they measured that evidence against the wrong standard, and it's that they looked at that evidence on only one side of the scale, never considering the collective weight of respondents' multiple IQ scores taken together. I welcome the court's questions.
Do you?
What exactly did Atkins say the Eighth Amendment violation was?
I think Atkins laid down a general rule.
Which is?
Which is that you cannot execute the intellectually disabled, and the meaning of intellectual disability is something that states define with significant discretion.
What did Atkins say about determining what intellectual disability meant? I should use the word retardation.
Sure.
But what did it say that was?
I think that Atkins looked, and the Chief Justice put this well in Moore, is that the scope of Atkins reaches no further than the consensus of the states. So I think that to the extent there's content to that command, it's going to come from state consensus. But I really do think that Atkins largely, much as this court has done in the insanity context, outsourced the definition of intellectual ability to the states.
Counsel, I'd like to, you're focusing in on Atkins, but Hall and Moore say something very different than what you're saying. In Hall, Mr. Hall had scores between 9 scores over 40 years.
This is a DOJ
The
lawyer.
lower courts found a score of 71 and 80, only 2 of the scores to be valid. But Florida had a strict cutoff rule that said anyone with higher than a 70 could not be intellectually disabled. So you can't have a flat rule that says you get 1 score over 70. you're not disabled, correct?
Correct. I think that yeah.
And what Atkins also said, I'm quoting, for professionals to diagnose and for the law then to determine whether an intelligence disability exists once an SMN applies and the individual's IQ scores is 75 or below, the inquiry would consider factors indicating whether the person had deficits in adaptive functioning. Courts must analyze the STEM, and if the STEM includes 70, the defendant must be able to present additional evidence of intellectual disability, including testimony regarding adaptive functions. So for us to say what petitioner wants would disavow that language in Hall. It would disavow nearly the identical language in Moore. In Moore, he had 2 valid scores of 74 and 78. Nowhere did we suggest that courts had to aggregate, accumulate, medium them out, composite them, do anything else with them. What we had, and there the court held that the state courts had violated Hall when it discounted the lower end of Moore's STEM because he was malingering. The tests were valid, it had a SEM, the SEM was below 70, and then the court held, once the STEM in some of those valid tests were below 70s, the courts, quote, must continue the inquiry and consider other evidence of intellectual disability where an individual's IQ score, adjusted for the test standard error, falls within the clinically established range for intellectually functioning deficits. So you are asking us to tell courts below to do something substantially different than what we told them to do in Hall and Moore.
Respectfully, no, Justice Sotomayor. There's a big difference between saying you can move on and look at other evidence and saying you can then forget about IQ entirely. The big problem here...
Okay, that's something different. What you're talking about, then, is not a legal error by the courts below. You're talking about your difference of opinion.
No, it is a legal error twice over, and I think it's a helpful thing to spell out here, is that even if you look at other evidence, you still need to circle back and see how that weighs against the evidence on the other side of the scale. And in this context, that is going to be the multiple consistent IQ scores together. The two legal errors...
But that's what the the 2 experts, the 3 experts here did. There was Dr. King, I think one was Dr. Cuddy, who was the original expert, and then
Dr.
there was
Cuddy.
the evidentiary expert, Dr. Fabian, if
He's
I'm
a
not
surgeon.
mistaken. Each one of them did exactly that.
The
Your
Department of
Dr.
Justice,
King
this is the Department of
looked
Justice
at the
lawyer as an
scores and
amicus,
said, I'm looking
but
at the function.
supporting Alabama.
And I don't think he's on the lower end of 70 because when I speak to him, he speaks well, he can respond. I think he functions at a higher rate. The other doctors, which the district court credited and did many, many more tests than Dr. King did, looked at all of the tests, all of the results, and said, I'm convinced that his range is 70 and below.
So before turning to the experts, let me just emphasize what I think are 2 discrete legal errors with the way in which the courts thought about this under Alabama law. Even if you tend to look at the secondary evidence, you still need to circle back.
Are you saying it's wrong to do it? Do you say Alabama says it's wrong to do that?
Wrong to do what?
Look at secondary evidence.
I don't think there's any per se rule in Alabama that says you cannot look at this, but the difference is...
So there's no
Can you
per se.
tell us
Can you
what the
please
two-
tell us what the 2 legal
Sure.
errors are?
Thank
Thank you,
you.
Mr. Green.
So the basic idea is where you have all of this evidence together, are you measuring it against the right standard? So one legal error that happened below is that the courts swapped essentially a preponderance burden with a possibility burden. But the other part is even putting that to the side, the difficulty is that you still need to figure out what the ultimate question Alabama law is asking here, which is this other evidence strong enough to drag down the collective weight of IQ
So that
below
seems
the line?
totally right to me. So I'm wondering, you heard the question that I asked Mr. Overing, and I'm wondering if we disagree at all. If I say The thing that Hall and Moore require is that when you have a score that's 70 or below, you do have to give the defendant an opportunity to come in and to talk about adaptive functioning. But having given the defendant the opportunity to talk about adaptive functioning, yes, of course, you can go back to the scores and to the fact that there are a lot of scores on one side, the upper side of 70, that make you think that that evidence of adaptive functioning just cannot possibly carry the day. Is that what you're saying, or are you saying something more than that?
I think I agree with 95% of it, or at least with one or two asterisks. And let me say how I think that cashed out here, and then what the constitutional rule is for how you just think about IQ. The issue is that what you were describing before just did not happen here. The only time that the courts grappled.
Okay, so I take that point. Let's presume that I don't care about it for the moment.
Fair enough.
You know, that all I'm trying to do is to figure out the rule, and then we can go back and say whether the court did it or not do it.
So I think that the part where I disagreed with what you said before is just in the sense that a single low score in all circumstances, no matter what, will always preclude a state from being able to focus on IQ. So imagine, for instance, just a case.
No, I don't think it would. The only thing that I think a single low score does is to say, yes, at that point, the defendant does have to have the opportunity to come in with adaptive evidence. And I take Hall and Moore to have that is their holding.
Right. So I think I take it slightly less categorically than you do, which is just to say, so you imagine a case of 10 85s and 172. The collective error range of those scores, even if you look at the 95% confidence interval, is not going to grace 70 or below. So imagine a situation like that where I think you can structure it where the possibility remains
okay,
so
so
low.
that's like the hypothetical that you gave in your brief, like there are a lot of 90s, and I kind of take that point, right? Because like at some point, there's no clinician in the world who's going to say that just because you have like one outlier score, that there's a possibility, right? If you have like 6 90s and a 72. But if you have something that's more along the lines of here, right? Then I take it that we are in agreement, tell me if I'm not, that at that point, the Hall and Moore ruling is you have to allow the person to come in with adaptive functioning evidence, but of course, may I, Mr. Chief Justice?
Sure.
But of course, you can say this is outweighed by the fact that there's a multitude of scores on one side.
Yeah, I think that there is broad, and if I can just stress the two key points of agreement is that moving on doesn't mean you're done. It involves circling back to the standard that state law imposes. And I think in turn with that, it's helpful to clarify what I think is now a point of agreement, that the one low score rule reading of Hall and Moore, where prong one is satisfied substantively, so long as you have one low score, is wrong.
Right.
Yeah.
Okay.
Thank you, Counsel. Justice Thomas? Justice Alito?
Let me see if I understand the colloquy you just had with Justice Kagan and the degree to which you agree with what she said. Did either Hall or Moore hold anything with respect to how a case must be treated when there are multiple scores? Hall and Moore talk about one score, and they say that dealing with multiple scores is a complicated matter. But do they say anything about how a court is to deal with a situation where there are more than one scores?
No, not expressly.
So if there is a case with one score and the standard error of measurement has a range that is below 70, and that's it. That's all that's in the case. One score, standard error of measurement is below 70. Yes, Hall says that allows the prisoner to proceed with evidence about adaptive functions. But it doesn't say how the court is to deal with a situation where there are multiple scores.
That's correct. And this is what I was trying to get at before, is that I do think in a lot of the solutions that I think might come with concerns that come with looking at injecting adaptive functioning into this space is I do think states have some discretion about when you want to sort of focus on IQ alone as a threshold matter. And I do think to the extent that a defendant or just can't come in and show that your multiple scores have any realistic possibility of dipping below any concerning range, that is a time where a state can say, we don't want to inject any of this other stuff into it, just focus on IQ.
Okay, so what we are looking for here under our precedents is the evolving standard of decency that exists on this issue about how to decide whether someone who's sentenced to death has significantly sub-average intellectual functioning. In prior cases where we have tried to determine what the national consensus is, we have looked at state laws, things that are enacted by the state legislature on the theory that they reflect the moral judgment of the people of that state as expressed through their elected representatives. But what do we do with a situation, and let's say that if a state made the law through case law without thinking that it had to do something one way or the other because of our decisions about constitutional standards. Put that aside. What do we do with a situation like we have here, where state courts and lower federal courts are trying to figure out what we said and what Hall and Moore mean? And so their decisions reflect their interpretations, perhaps erroneous interpretations, of those two precedents of this court. Do we look at those to see whether there's a national consensus?
No, I don't think so. I think there's a difference between the idea for a national consensus is when a certain moral judgment has the imprimatur of the people. I don't think that happens when a court imposes that standard on an incorrect understanding of federal law. So to the extent that this court is still doing head counting for purposes of Eighth Amendment, I don't think that courts misunderstanding Hall or Moore would factor in favor for whatever new rules being proposed.
Now, I don't know whether you've surveyed the state,
this really bothered me in Atkins.
statutes, so perhaps you're not in a position to answer this question. But if one were to survey the statutes of all the states that have the death penalty and see whether they have adopted one approach or another approach to the situation we're dealing with here, what would we find?
So I can't speak to the legislatures just because I don't know what was motivating them. Alabama was able to catalog, I think, a few examples in their brief of instances where state courts were applying what is essentially the one low score rule. That erroneous understanding of Hall and Moore, which again we all agree is an erroneous understanding of Hall and Moore, I don't think that that counts as a moral endorsement of the one low score rule.
Now, Justice Kavanaugh asked your friend about the advantages and disadvantages of a safe harbor as opposed to the alternative. And maybe you would, I'd be interested in what you have to say about that. If there's a safe harbor in the sense that a person sentenced to death who's claiming intellectual disability has to meet some concrete standard before the case can go on, will there not be greater consistency and predictability? And is that not one of the lodestars of the court's death penalty jurisprudence, as opposed to a situation where everything is up for grabs in every case, and both sides can bring in experts to testify about the person's intellectual disability or lack of intellectual disability, and every trier of fact is going to decide that on an individualized basis?
So I 100% agree with that, Justice Alito. If I can just emphasize one point, because I don't think there's any practical daylight between what I'm saying and what Alabama was just talking about. I think just the point I was making before is there might not be a per se legal bar on looking at the other evidence, but the IQ evidence may nonetheless be practically dispositive in a given case. So what I'm understanding essentially what my friend was saying is, well, if we look at the IQ scores, it was the defendant or respondent's burden to essentially show at step one that the error range of those scores together reaches 70 or below. Because even if that range never reaches 70 below in the first place, there's no realistic possibility that any of this secondary evidence on the other side of the scale is going to drag you over. So I think that that's more of a practical matter with the facts of this case, where IQ happens to be dispositive just because there's not going to be anything on the other side of the scale that tips it over.
Thank you.
I'm not sure how that happens. There were 9 scores in whole between 71 and 80. And we still sent it back for the court to consider additional evidence, including adaptive functioning, correct? What Justice Alito is saying is states could do something like he suggests, but is that constitutionally required?
I think the difference, though, is...
Answer my question. Would states have to do it that way, or could they do it now in whatever way they thought, one of the 5 ways suggested by the other side, or the way they're actually doing it now?
The answer is uncertain for the reasons I was explaining with Justice Kagan. And I can't, I'm not good enough at math to do this on the fly, but the basic idea is that if those collective scores do not produce a range that even graces
Has
70,
any state
I don't think there's any
adapted that
constitutional
measure?
bar.
Has any state approached the issue that way with multiple scores?
I don't think so. I think
Did Dr. King approach it that way below?
In part, I think we focused on IQ and said that it did not fall below 70, and then also said that the other evidence on the other side of the ledger wasn't strong enough to show any other form of disability either.
What I thought he did was exactly what all the experts did, is 3 of the 5 fell within intellectual disability, and then he relied on adaptive functioning to say he thought he was not intellectually disabled.
Let me make one quick point, just addition to this, is that what you won't find in any of the expert reports is a conclusion with respect to what Alabama law asks. None of them found that respondent's true IQ was likely 70 or below. So finding that respondent did not satisfy his...
I'm sorry, who didn't find that?
No expert in this case. You won't find any...
Wait a minute, that's what they did say.
No, it's
2 of them, at least 2 of respondents' experts found he was intellectually disabled. That was the finding the district court made.
It depends what definition you're using. The experts were using clinical definitions that are distinct from Alabama law.
I don't disagree with you, but the district court was following Alabama law. These things are not statutory. Most of these, the very few, maybe Oklahoma is now, where 1 score above 76 disqualifies you. I don't know how that's not different than the 70, 1 score above 70 situation might be. But we'll look at Oklahoma when it comes to us.
Sure. The only one thing I'll add is that I don't think the district court was following Alabama law because, as my friend emphasized, I think a very telling point is that you will not find a single sentence in anything the district court wrote that said respondent's IQ is likely 70 or below. We think that they were laboring under...
Oh, is that what you think is they did wrong?
I think that what I was trying to get at the start is there's 2 problems. They misunderstood the standard for a possibility idea from the 1 low score rule.
That was only the 11th Circuit who said that. The district court certainly didn't say that.
But then the basic part 2 is returning to what Alabama law is, which is a numerical inquiry. Does the evidence show that you've been able to drag down the IQ scores below 70? There's no engagement with that. The basic idea...
But that was never argued by Alabama.
Oh, no, it was one of their leading arguments, which was that you did not consider the totality of the evidence. And when you're trying to figure out whether the secondary evidence drags the IQ down...
That's all right, I'll stop. But that's attributing to one broad statement, a specific argument that I don't see. Where did they say that the adaptive functioning should be ignored because the cumulative effect of the score showed he wasn't?
It's 2 sides of the same coin. What it's saying is there's no need to move on to other stuff because here, respondent hasn't even carried his initial burden of showing it will do any good.
All right,
Thank you, Justice Kagan. Justice Gorsuch.
A few questions there where I don't think you got to finish your answer. Here's your shot.
I would be pretending if I remembered what any of those questions were. So, I think instead of, turning myself into a circle, if there's anything, that you wish I spoke to.
Well, no, there isn't. I want to get what your argument is. I'm here to understand it,
right.
not anything else. And I think one of the questions was, what do you think the error was the district court made and that the 11th Circuit made? I think that was one question that I'd like to hear the answer to.
Right, so I think there's 2 related errors. And the first is what we were saying before, is that they just misunderstood what the substantive standard is. I'm going to look at this evidence. I'm going to ask whether there's a possibility. Alabama looks for a likelihood. So that's mistake number 1. But the second part is, even if you say it's applying the right standard, there's still a basic analytical error because if you look at the opinions below, once the courts consider multiple IQ and conclude that it's theoretically possible respondent's IQ dips to 70 or below, IQ falls out of the case entirely. And that's a basic analytical error because, of course, not all possibilities are the same. A defendant with one score of 75 is going to have a really different burden than a defendant with 100 scores of 75. So the analysis here, what it should have looked like, is taking count of that dynamic, which is not just saying, well, there's a possibility IQ falls away. I'm going to look at this secondary evidence. You then needed to circle back and see if that secondary evidence was strong enough to drag down the IQ scores below the line set by Alabama law.
And the first error, though, might be itself dispositive, it sounds like.
Yeah, they're independent errors.
Either one of which is sufficient.
Correct.
Okay. And you agree that at the end of the day, before a federal court can grant habeas relief, it has to find a violation of the Eighth Amendment here.
Yes. Can I add one piece to it? Is that
if you must.
The wrinkle here, which I think is a bit difficult, is the innovation
Christopher, did you see that
which
message
is
from
to
Ant?
Innovation, that was the word I was looking for.
which is to identify a federal rule, a general rule against executing the intellectually disabled, but largely outsourcing its definition to state law.
At bottom, though, I agree with that. That's an innovation for sure. But it was trying to give some breathing room to states. Mm-hmm. There has to be a floor, an Eighth Amendment floor beneath all that breathing room, right?
Yes.
Presumably. And before a federal habeas court can grant relief, I would have thought you have to find a violation of federal law.
Yeah, I think that, make of it what you will, but I think the formal way in which it would work is there is a violation of Atkins, federal, because one way or another either met or did not meet, or not even whether or not you satisfied Atkins turns on whether you satisfied state law.
Even if state law is well above the Eighth Amendment floor?
Oh, I understand. And that, I think that the answer would be probably yes, although I think it's difficult.
Really? Is it that difficult?
Well, I think that states have broad discretion to set. I do think that at some point, what I will say, let me take that back just a little bit. In that, yeah,
really,
that states are free to be more protective than what the Eighth Amendment requires.
How many times have we held that?
Gorsuch,
100%. So, for instance, what meant to say is, imagine a state adopted the one low score rule as a matter of state law. Whether or not you violated that wouldn't necessarily implicate the Eighth Amendment because it's more protective than what the Eighth Amendment would require.
Exactly. And so before a federal habeas court could grant relief, you still have to go beyond that and find a violation of the Eighth Amendment.
Yes.
Okay. I'm glad we got to that. Okay. And then what do you think about the holding that I suggested to your friend from Alabama, looking at what Hall and Moore and trying to figure out, because I agree there is some confusion, and that's why we took the case, the QP we did, was trying to sort some of that out. That under Atkins, states can implement the first prong however they want, as long as they don't treat a single score in the low 70s as decisive, Hall, or use facts extraneous to IQ scores to outweigh a low score, Moore. Is that a correct and fair summary of the law that would provide guidance, do you think?
100%.
On the constitutional floor that you were just exploring, I want to ask the questions to you that I was exploring with Alabama's counsel. If the median is above 70, I understood them to say that the defendant cannot make out a successful Eighth Amendment claim, even if they might have something under state law. Do you agree with that?
I don't think that the Eighth Amendment necessarily speaks to that one way or another. I mean, again,
so you don't agree with that then?
Well, I think that the standard for what the Eighth Amendment is, at least under Atkins, is going to only the Eighth Amendment strictures are only going to reach as far as a nationwide consensus mandates. So when it comes to those specific issues, to the extent there's no nationwide consensus on the question, no, I don't think you run afoul.
So what happens when the median is above 70? Or when I assume you're going to have the same answer on the overlap as well. So the overlap approach, let's say as here, 73 to 77, they're saying when that's the case, you cannot make out a successful Eighth Amendment claim, period.
I think that.
Do you agree with them on that?
So I agree that it's practically dispositive under law.
You said that. I wrote that down. Practically dispositive. What does practically, as opposed to legally dispositive, mean?
Because I think that it's not to say that that there's some per se legal error to moving on to other evidence in light of
the other evidence. Then, when you move on, if you're saying they can move on, or over the state's objection, you're saying the other evidence, in some circumstances, could outweigh the scores even when the median's above 70. Let me finish. Or when the range is something like 73 to 77. In those circumstances, unlike the state, you're saying the other evidence could outweigh in some cases.
I'm not saying it could outweigh. I think there's a difference between a constitutional rule as to whether or not you need to consider it. But I think in a circumstance where you have consistent scores that are in the high 70s, this is what I mean by practical.
Well, if you're saying that you could consider it, but it's not dispositive, like the state says, then I'm trying, is this just for going through the motions or what?
But I think this is a product of, again, this is going to be a product of state experimentation. If you have a totality of the circumstances inquiry in some measure, it doesn't mean all the evidence is equally important. So even if you decide to look at other evidence for one reason or another, the IQ scores might be so strong that there's no realistic possibility that other evidence is going to drag the IQ scores down.
I'll ask it again. If the median's above 70, the state says end there. You're saying no. You can go on to consider the other evidence. The defendant can have you go on to consider the other evidence. In some cases, can the other evidence outweigh the scores even when the median is above 70?
So, yeah, I can imagine a circumstance, hypothetically, where, suppose you have...
That's a yes. That's, okay, that's different from the state.
Again, I think that, so imagine a circumstance where you have two scores of 71. And then you come in and essentially you have an expert say, well, the content of those IQ exams tested A, B, and C aspects of intellectual functioning. I have all of these neuropsychological batteries that test other aspects of intellectual functioning, and they're really, really low. I could imagine that being, in a state that has decided to adopt the totality of the circumstances inquiry. That would be a kind of circumstance where, yes, the other evidence could put you below the line.
So I think it would be constitutional error then for a court to say the median is above is 73. That's the end of it. You can't prevail on an Eighth Amendment claim. That would be constitutional error?
I would be reluctant to phrase this in terms of median, composite, whatever it might be. And this is what I was trying to get at a little bit with Justice Kagan, is that there is some point, and Hall, I think, blesses this practice. There's some point where the possibility of your scores dipping to 70 or below, is remote enough that you can rely on IQ exclusively. I don't think this court's precedence paints with a bright line. It certainly doesn't mandate at this point a specific median number, but I think that's the nature of the inquiry.
That's where you differ from the state. The state really was pretty definitive on that, and you're not, which is fine. I'm just trying to explore, because we're going to have to dig through a lot in this case to explore kind of the difference.
But again, this is, returning to the part of, is it a real-world matter? I don't think it's going to make any difference here with the idea of...
Here, meaning in this case?
Correct.
Okay, that's all I need. Thank you.
Mr. Graver, I just want to clarify. It seemed to me that what you were telling Justice Kavanaugh might have been different than what you said to Justice Gorsuch, and I want to make sure that I didn't misunderstand that. When Justice Gorsuch read you his proposed rule statement, it didn't include anything about necessarily having to consider the evidence of adaptive functioning, but I understood you to tell Justice Kavanaugh that you would have to go on to consider such evidence, and that in some circumstances it could outweigh the IQ scores, even if they were in, say, the 73 to 78 range. Is there a difference, or am I misunderstanding?
I think a little bit. The part that I would want to focus on is the adaptive functioning piece, is that there's some aspect, I think, as we were getting at, there's some rule of Hall, taking Hall at face value, that at some point IQ scores alone can't be the only thing you're looking at. I do think states have some discretion after that to structure what the other evidence is. And I would imagine that a rule that, for instance, focuses just on conventional evidence of intellectual functioning would be constitutional. The way in which if a state imposed that substantive standard, the question that would follow is, well, are Hall's references to adaptive functioning, that dicta itself, is that something this court wants to give the force of law, that you need to consider this bucket of evidence in particular? I don't see any constitutional mandate to do that. But I think the only point is that so long as your scores touch a certain level, perhaps IQ can't be the only thing you're considering at prong one.
Okay.
Justice Jackson?
I have to say, I think that the arguments and assertions in this case are all over the map and very hard to follow. So I'm trying to understand how and to what extent the district court erred in this case,
from an old
given
case.
the law as it existed at the time the district court ruled, as opposed to the law that Alabama wishes it had enacted or the cases that it wishes it had already put into place with respect to standards that it's coming up with now. So I understood you to say that there were two errors, something about likelihood or possibility versus possibility. And the second is the one I'm most focused on, which is that under Alabama law, you understand that the law is and was at the time of the district court that if you're looking at secondary evidence, was the secondary evidence strong enough to drag down what you had gleaned previously from the IQ scores? Is that what you understood Alabama law to be, and therefore it was an error for the district court not to apply it?
Yeah, and I don't think it's an IQ-specific insight. I think it's just a common sense point about the nature of how preponderance
I just want to know if it
work.
existed as a standard so that we could say the district court erred.
Yeah, I think that when you need to show that a fact is more likely than not in light of the totality of the evidence, you can't then exclude the most probative evidence as part of that weighing. So the issue here that the district court did is it said that the IQ scores allowed it to move on to other evidence, but then it forgot about the first half of the scale. It never looked at the collective weight of the IQ scores all above 50 to
But
see.
it did entertain expert testimony, and this is the second part of my question to you, is I'm trying to understand, there is a nub of this that's a question of fact, right? Is this person intellectually disabled? And I don't take it that you disagree that experts are going to be involved somehow in making this assessment, right?
Right.
They're not only testing, but they're also looking at other evidence to the extent courts allow them to. So what I understood happened in this case is we had a series of experts come in, evaluate not only the test scores, but also the other evidence, and testify as to whether or not they thought this person had an intellectual disability. Now, I appreciate that the state's experts said no, but the other experts said yes. And the court looked at that and made a decision. I don't understand why that's error from the court's perspective when we ordinarily allow for hearings with evidence and testimony that goes to issues of fact, and the court decides.
Right. So I wouldn't think about this as a battle of the experts cases.
But why not? We had experts who testified to this issue.
That's the part where I disagree with you. No expert testified to whether or not respondent satisfied his burden at prong one as understood by Alabama law. All of the evidence about intellectual functioning was measured against clinical definitions that are different in kind from what Alabama asks. So again, the experts offered in their insights.
Okay, can you point to a case in which Alabama says experts, you can only testify for the purpose of our law to the standard as we are now articulating it? Because to the extent that Alabama sat there and heard the experts testifying and didn't object on the basis that you're saying, or didn't argue to the district court, there's a problem with this testimony because he's testifying to things that Alabama law doesn't consider, I think you may have waived this.
No, I think the basic point is that it's not an all or nothing inquiry either way.
I'm just trying to understand what was argued below. If you're now saying the problem with the testimony before the district court of the experts is that it wasn't focused in the way that Alabama law requires, where's the objection from Alabama below saying that?
The fact that it doesn't answer the entire legal analysis or legal question before the district court does not mean the expert testimony is not relevant. But the district court then needs to take that evidence, put it into the equation as structured by Alabama law. So what I mean by that is that it is true that the expert said, well, the secondary evidence has a bit of a downward pull, but that is—
The expert did say that.
But that is the start, not the end of the analysis. And that's the key problem with the district court, is that it never looked back to see the weight of the thing that it is pulling. Because essentially what it said is this downward pull is dispositive. It never returned to the collective weight of the IQ scores as part of that analysis.
Thank you.
Thank you, counsel. Mr. Waxman?
There we go. Number 3. Here comes Mr. Waxman.
Chief Justice, and may it please the court, just to clarify one thing, the statutory standard in Alabama for prong 1 is substantially sub-average intellectual functioning. Now, courts sometimes use the term, and properly so, true IQ of 70 or below, but every court in Alabama and this court and every other court in every other state that I am aware of understands that raw observed test scores is not the definition of true IQ. Now, in deciding whether a defendant has carried his burden to prove that he suffers from substantially sub-average intellectual functioning, Alabama law, like that of nearly all other states with the qualified, sometimes exception of Oklahoma, requires courts to evaluate all probative evidence as to intellectual functioning offered by either side. That includes evidence of intellectual functioning other than IQ test scores, at least where a court, considering expert testimony, concludes that those scores alone don't decide the issue. The courts below did exactly that by evaluating evidence of Smith's significant impairment on other neuropsychological tests of intelligence. This is pages 88 and 90 to 92 of the petition appendix. His grade school records, which showed that on every measure he was 2 to 4 years below grade average, culminating in a diagnosis of mental retardation in the 7th grade. The warden and the Solicitor General ask you to reverse the lower court's faithful application of Alabama law, and I am holding all 12 reported cases on this issue post-Hall in Alabama, and there is not a single case, including the 2 that my friend mentioned, in which the court said, we're only going to look at the test scores, we are not going to consider other evidence. In Perkins itself, which is the lead Supreme Court case,
Thank you.
Before you go on with the another granular argument, what is precisely, to your understanding, is Alabama law?
Alabama law.
Just the pure law, not this case. What does it require?
Alabama law requires that in evaluating whether an individual is intellectually disabled, 3 prongs must be met: substantially sub-average intellectual functioning, substantially sub-average adaptive functioning, and onset before the age of 18. And the Alabama Supreme Court in Smith versus State specifically said and subsequently repeated that the Alabama legislature has adopted the most liberal definition of intellectual disability for purposes of the Eighth Amendment.
Excuse me, but do you agree that compliance with Alabama law would be compliance with the Eighth Amendment?
In this instance, yes. I could imagine a situation in which, Alabama said, we're just never going to execute anybody who gets a score.
Well, let me just put it a different way. Do you think that the statement, in theory, the pure Alabama law, not an application year, is enough to comply with the Eighth Amendment?
In this sense, given the way that Alabama has defined intellectual disability, yes.
Okay.
In other words, to go to Justice Gorsuch's question of both of my friends earlier, of course a federal court, and here a court is not sitting, this is not a post-conviction, EDPA-type review. The trial court never held this hearing and heard this evidence. It is certainly true that a federal court cannot reverse a state sentence unless it violates the Constitution. That is exactly what both lower courts held, and that is got to be the case because, as Atkins explains, federal constitutional law in this area incorporates state law.
Do you think the Eighth Amendment means something different in Alabama? Could mean something different in Alabama than it means in, let's say, Florida or Texas?
No. I mean, I think may I just add one sentence?
Sure.
As we've pointed out in our brief in the appendix, and I'm happy to answer questions about it, there is no state, every state that has considered multiple test scores post-Hall, may also be true pre-Hall, has said if there are multiple scores whose SEM ranges individually reach 70 or below, you consider other evidence that is relevant to intellectual functioning. That is a consensus.
If the Eighth Amendment has to mean the same thing in every state, then there is the conundrum of Atkins' reference to the discretion that is afforded to the states. And one possible interpretation of that seems to be the one that you are advocating, which is that federal law somehow incorporates state law, so that in determining whether there's an Eighth Amendment violation, the court is to determine whether there was a violation of state law. But isn't another possible interpretation of that the following, that the Eighth Amendment, as understood in Atkins, gives the states discretion, but there is an Eighth Amendment floor, and the Eighth Amendment floor is what cannot be, you can't go below the floor. And the floor is whatever a definition of intellectual disability, procedures for determining intellectual disability that are impermissible. And so long as a state does not go below that floor, a state court does not go below that floor, there's no Eighth Amendment violation.
I'm not sure. It seems to me so long as the state court does not apply the quote, means to enforce this constitutional rule, which is the language of Atkins, in a way that is inconsistent with the Atkins principle that persons whom a court interpreting court law that itself is applying the Eighth Amendment standard considers to be satisfying of all three prongs. In other words,
so I take that as an agreement that it would be possible for a state to come up with procedures that would violate the Eighth Amendment, right? I mean, you wouldn't want to rule that possibility out.
Oh, of course. I mean, that was exactly what happened in Hall, and in Moore, for that matter, and in Brumfield. And in every single one of those cases, the court remanded to the state courts, which then heard all of the relevant evidence, not just IQ test scores, all of the relevant evidence, and concluded that the defendant had, in fact, satisfied his burden to show all three prongs.
Mr. Waxman, if a state law goes above what we might say the Eighth Amendment floor is, and a federal habeas court deviates from what state law requires, does it violate the Eighth Amendment?
No. I mean, the example would be, let's say a state said, look, we've read all the other cases, but in our state, we're not going to execute anybody who has a true IQ below 80. And we're going to hear all the evidence, but a true IQ below 80, you win under state law. A federal court couldn't say.
Couldn't grant habeas in that circumstance.
Right. Yeah. Right, unless there was a compelling argument that the true IQ was below 70.
Right. Right.
Yeah.
But it might be a violation of state law, but it isn't a violation of the federal Constitution.
That's right. But what we have here is a situation in which every state, with the limited, very limited exception of Oklahoma says IQ test scores are not the same are not equivalent to substantially sub-average intellectual functioning, because that is a condition, not a test score. They are highly probative, considering the standard error of measurement of what actual IQ is.
So we don't have to really consider Alabama law, because what you're articulating is the Eighth Amendment standard as you see it, based on what you're pointing to in a consensus of the states. But just to kind of clarify the position on this thing we've been going back and forth with about what is the role of state law, really Alabama law here does not matter to your argument.
Alabama law matters a great deal to my argument because, as this court has taught, we leave it to the states to apply appropriate means for enforcing the Eighth Amendment guarantee. And that is what the Alabama appellate courts have said repeatedly that they are doing in considering both evidence of IQ test scores, if there are any, and where those scores are determined upon expert testimony to be inconclusive, other evidence of intellectual functioning, including, in this case, 4 other psychometric tests that test intellectual functioning, and a history where in the 7th grade he was diagnosed, medically diagnosed as mentally retarded. And considering all those factors, the court found, both the district court and the Court of Appeals made clear on remand, that with respect to evidence of intellectual functioning, including but not limited to test scores, he satisfied prong 1. The Court of Appeals then went on to say, in its opinion on remand for this court, that the additional evidence, I'm quoting from page 8A of the joint appendix, which is quoting from Hall, the additional evidence of Smith's adaptive deficiencies plausibly supports the district court's reading that although Smith scored above 70 in IQ tests, his actual functioning is comparable to that of individuals with a lower score.
Thank you, Mr. Rox.
Thank you.
Putting aside how it applies in this case, the SG's methodological approach, as I understood it, I want to make sure whether you agree or disagree with it. What I understood the Solicitor General to say is that the scores, you start with the scores, but then you have to go on, usually, maybe always, to consider all the other evidence. But then when you make the final evaluation, you can't forget about the scores as part of the overall analysis.
That is, I agree 100% with that, and the district court did nothing of the sort.
Right. On that latter part, I know you disagree, but on the methodology, anything you disagree with the Solicitor General on?
My memory is even worse.
I'll push it a little further. I mean, it's possible that the place you do disagree is, I think that the Solicitor General had an exception for scores that were, this is his, in the brief, the, many 90 scores. And he said, the scores can be such that you wouldn't have to. I think
Got it.
Testimony, maybe even agreement, that the 71 is in fact the result of malingering, or that it is a statistical outlier, and taking into account other evidence relevant to intellectual functioning should be disregarded. But I think a constitutional, a state court that said, come on, the guy has 4 90s and 171, and I've heard expert testimony on both sides, and I find on the basis of that the defendant has not satisfied his burden of proving by a preponderance. What we have here are 4 or 5
on that hypothetical,
if I may just finish my sentence.
Yes, sure.
What we have here are 2 experts who said 4 of the 5 scores are within the range of intellectual disability. The district court itself specifically found that, and so we're not in that hypothetical range, but I agree with the Solicitor General.
Oh, indeed.
On that hypothetical, 3 or 4 sentences later, on that hypothetical, would it be...
I couldn't contain myself, I'm sorry.
I know.
I apologize.
Never. Would it be permissible for a district court to say, well, you got 4 90s and 171, that's enough?
That's enough what?
That's enough to show substantial, significantly substantial, significantly substandard intellectual functioning. It could do that in that situation.
I mean, the review is for clear error, and unless there were some compelling testimony to discount the 4 90s, it would be clear
There's
error.
no situation in which IQ scores could in and of themselves be sufficient. So the court could say, look, I've looked at these IQ scores, and that's enough. The statistical possibility that the true IQ is below 70 is so small that the defendant can't possibly prevail.
I mean, I'm not aware.
The court always has to hear additional evidence about adaptive functioning.
I don't think that's the case, and in fact,
I thought you said just the opposite. Is that not right? You said the court in that case would not have to look at adaptive functioning evidence.
right. I mean, if there's going to be expert testimony, pro and con, with respect to the administration of these tests, and if the court hears the expert testimony and says that on balance, I credit the expert who says that the 71 was a result of malingering, or that the 71 is an outlier, or that the 71 tested, as my friend the Solicitor General's assistant says, tested certain aspects of intellectual functioning, but not others that are really important, and it should be discounted. A district court that credited that testimony would not err under the Eighth Amendment,
Well, what you
so
say,
long as it was consistent with state law.
what you say in your brief is that there is near unanimous consensus of the
Izzy, I'll
states
go back through
that
this
multiple
but a little bit
IQ
later.
scores must be assessed holistically in light of all relevant evidence.
That's correct. And
So if there are multiple IQ scores, there are 5 100s and 171, the court can't just say the defendant cannot prove that he's intellectually disabled. The court would have to hear additional evidence.
the court would certainly have to hear expert testimony about the reliability of the, what are we up to now, 500s? But a court would certainly be within, assuming state law permitted it, a court would certainly be within its rights to say there is no other evidence of intellectual functioning that could reasonably convince me that this man who doesn't fall remotely within the borderline, even taking the most generous standard error of measurement, and I'm ending my inquiry there. You would have to be able to show evidence on one side or the other that the test scores are in fact were properly administered and reliably interpreted. And there are Alabama cases in which the state has offered extraneous evidence, that is evidence other than test scores that go to intellectual functioning, to say even though he scored within the range of 69, he's not intellectually disabled.
So the
And
court
so I
is,
think
or
your
the state's
arguments
using
or
this
your
the other way.
responses to Justice Alito are all really heavily focused on the fact that what the court is actually doing is hearing intellectual functioning in light of expert testimony about these things. And so it seems kind of odd to have rules that would be rigid with respect to how these particular experts are testifying or what the impact of the various scores are in this environment, I think. I mean, am I right about that? Like, part of the confusion that I'm having is that Alabama and the SG seem to want to remove the evidentiary aspect of this and make it into just a question of law, as though the court, without evidence, is just making this decision. When in fact, the court is hearing from experts who've looked at the test scores and all of the evidence and are testifying as to their beliefs regarding this particular legal criteria. And then the court is deciding.
Let me make 2 points in response to that, Justice Jackson. First of all, it's too late and irrelevant for me to pick sides in Moore versus Texas, but what the district court did in this case is precisely what the Chief Justice in dissent said was properly done in Texas. A court hears the evidence, all probative, relevant, and admissible evidence on both sides, and makes a determination against the standard, the Eighth Amendment standard, with whatever procedural or substantive applications that state law provides. And in this particular case, what I understand the state to be saying is, look, as a matter of Alabama law, whether you're talking about, I don't know, the overlap or the average or the median or whatever, if you don't have an actual score at 70, you don't get to, it is error, clear error for the court to hear other evidence that is probative of intellectual functioning, including other psychometric tests that test intelligence as well as adaptive functioning, and the fact that the guy was diagnosed as mentally retarded in the 7th grade. Of course a court should be able to determine that. There's just no warrant for this court to announce a constitutional rule binding on all states that precludes consideration of evidence that Alabama and the other states and the medical community properly considers probative of intellectual functioning.
I think that would be setting a floor for all states, not binding the states. The states could always go above the floor. But in any event, I understood Alabama and the Solicitor General to have different views on that, and that Alabama has that view that you just said, that if the scores, the median or the overlap is above 70, then that's it. You can't make out a successful Eighth Amendment claim. I understood the Solicitor General to say, no, you still go on and consider the other evidence, but don't forget about the scores. I gather methodologically, you agree with the Solicitor General. You think Alabama's wrong on that.
Well, I think
it's not really a question, but you can say yes or no to that.
Yes, because, number one, there is no Alabama case that, and there was no evidence in this case with respect to whatsoever applying some aggregate score as the test for true IQ. Absolutely not.
But then,
median, you know,
Counsel, let Justice.
Oh, I'm sorry, Justice.
you can have one sentence.
I will
You're also
reserve
using
my
the word
one sentence
because
to answer
it was
your
the word
question.
used.
I apologize.
Mr.
20
Graber
years
doesn't
ago
get a
in
chance
the
to
last
stand up
case,
and
or
tell
30
me
years ago
whether
in
I'm
the last
wrong
case.
about my summary of his, but then I think he would say, okay, you agree on that, but he says that the court here made two fundamental errors. One is it treated the preponderance standard as a possibility standard, and the second is it thought that it was not permissible for it to get back around to the scores. And he says that those were the two errors. Were they? Is that right?
No, I
Graber?
think that the district court's opinion refutes both of those contentions. The district court plainly and expressly found by a preponderance of the evidence that he satisfied prongs 1, 2, and 3 independently. I don't even remember what the second part is, but that would be.
So the second part is important because Mr. Graver says that the court thought that it couldn't get back around and say, look, there are 5 scores here. Most of them don't reach the 70 threshold, that sort of thing.
You know, the court said that he'd showed, I mean, the court's opinion discusses each test score. It discusses each of the 4 experts' testimony. It discusses what the experts showed about the other psychometric intelligence tests, about his history, and what each expert said about that, and then concluded applying Alabama's standard of substantially sub-average intellectual functioning, that he, by a preponderance, he had met that standard.
When you talk about that standard as Alabama's, that's straight out of Atkins, isn't it?
It's straight out of the Alabama statute.
Also straight out of Atkins, isn't it? And Hall and Moore.
Atkins.
And you say it's at the same standard everybody except for Oklahoma uses it. So
Oklahoma
presumably they all use it for a reason because it came out of our decisions, right?
Well, no, the reason it came out of Atkins was Atkins found that there was unanimity among the expert practitioners and associations.
Oh, fine. Whether the chicken or the egg came first, it's in Atkins.
We're in violent agreement.
All right, thank you.
Counsel, Mr. Waxman, I don't do this often, but Justice Gorsuch set out a statement that he asked the other side whether it was a holding that they disagreed with. You read something.
I did.
Yes, you did.
You want me to read it again?
Please, because I'd like Mr.
I don't
Waxman.
remember it, so I
No,
appreciate it.
and I took it down, and I can't find my notes now. So could you please, if you do that?
I would be delighted.
Okay.
The question is just how to understand, which I've struggled with, both Moore and Hall. And I read Hall as saying that you cannot treat a single score in the low 70s as decisive. And I read Moore as saying you can't use facts extraneous to IQ to outweigh a low score. Fair?
Fair with the caveat that extraneous to IQ. Well, no.
I mean, that's what the court did.
If what you mean is extraneous to the question of what his true intellectual functioning is,
No.
yes.
Yeah, it started looking at things to try to outweigh a low score. It started grabbing at other facts.
Well, it not only, I think it would be a due process violation for a court to say the evidence on the test scores is inconclusive, but I'm not going to let either the state or the defense put on evidence. I mean, this court has Washington versus Texas and Crane versus Kentucky and any number of other cases basically stands for the proposition that you can't artificially limit presentation of evidence that is relevant, probative, and admissible.
In Moore, counsel, the two scores were 74 and 78. And the court, and we held, the state court violated Hall when it discounted the lower end of the SEM because he was, quote, malingering. There we held that when there's an IQ below 70, with the SEM that adjusted for this test standard error, then you must permit evidence of whether clinically he falls within the range of intellectual functioning details, correct?
That is a correct holding, and my understanding of the disagreement between the majority and the dissent was leaving aside the Briseno factors, whether a district judge committed clear error in determining the case determining the issue the way it did.
And so Justice Gorsuch's second reading is wrong. We do require clinical evidence, but the finder of fact could rightly not be persuaded by it, or it could be persuaded by it. That's your point, isn't it?
That's correct, unless the court concludes that I've got, let's make it now 10 IQ test scores, all of which both experts agree were properly administered and reliable. And in light of that finding, one test score of 70, there is no evidence other than the testimony of the experts that could change my mind that he has not met prong one.
But that's not the case here.
I mean, we're not in the same time zone as that.
No, because we have 3 tests, all of them.
4.
4, all of them within the SEM, he could be 70 or below.
He could, and he in fact demonstrated by a preponderance that he is.
And in fact, Dr. King, whom they rely upon, the petitioners, testified that the scores were within intellectual disability, but then he went to other factors to say why he thought he was functioning within.
Well, I his testimony to be less credible than the other experts. What he said is, we have 5 scores and they're all above 70. 4 of them, looking at the individual standard error of measurement, are within the range. But he was asked a question by the prosecutor, are you aware of a theory by Dr. Flynn that when there are multiple test scores that are close together, the standard error of measurement will be reduced? And he said, yes, I'm aware of that. There was no testimony about what, in this case, that standard error of measurement would be, and it is inconsistent, flatly inconsistent, with what this court said in Hall and what, in at least 5 cases, Alabama courts have done, which is always apply plus or minus 5.
And in fact, they've
Thank
rejected Flynn, correct?
I'm sorry.
The district court rejected the Flynn effect in this case.
Yes, we're not relying on the Flynn effect.
Thank you, counsel.
Thank you.
Justice Thomas? Justice Alito?
It would help me to get clarification of your position on a couple of issues. I took from your brief and from your answers at an earlier point in the argument that whenever there are multiple IQ scores, they must be assessed holistically in light of all relevant evidence, and by relevant evidence, the relevant evidence would include evidence about adaptive functions. That's how I understood your brief. That's what I understood you to say at an earlier point in the argument. But then you just recently said, if there is a case where there are, let's say, 5 100s and 1 71, the inquiry could be cut off at the point. It would not have to get into any adaptive function. The inquiry could be cut off at that point. Is that correct?
I think, considering the expert testimony, if a court...
Expert testimony about the IQs or about other things?
About the IQ test administration and meaning of the test, a court could say, look, nothing you can offer is going to convince me that in fact his true IQ is 70 or below. That would be measured, that determination would be measured for clear error. In other words, what the court would be saying is, yes, of course, each side is entitled to offer.
Okay, so there could not be a categorical rule. There can never be a categorical rule that IQs plus testimony about the IQs is sufficient, and a court would err if it went beyond that and opened up the possibility of holding that there was not intellectual disability. You said it would with the court could do it, and that would be reviewed for clear error.
What I am saying is, if there are multiple one or more IQ test scores that are within the range of intellectual disability, that is 70 or below, it is error for a court to refuse to consider expert testimony and evidence relating to other psychometric tests and school and prior diagnoses to determine whether the defendant meets his burden to show prong 1.
So in just about every case then, IQs and testimony about IQs can never be sufficient.
I don't know how to, I've given you every possible answer that I have. I think a court looking at whatever it is, 500s and 171, considering the testimony about how those tests were administered and what the reliable results of those tests are, could conclude, look, that's it for me. There's nothing you could show me that would change my mind.
I'm still perplexed also about your view regarding the relevance of Alabama law here. Does it matter what Alabama law says on these points, or are we looking for the minimum Eighth Amendment standard?
What Alabama law says about how this is or isn't proven is the Eighth Amendment commandment of this court in Atkins. That is, it allows states to apply various standards in order to make a determination about the Eighth Amendment violation or not. As we know, the state can apply different levels of burdens consistent with the Due Process Clause. There are some states that say, if somebody is charged with a crime and comes in with a score of 65 even before the trial, he is presumptively ineligible. I mean, there are to enforce, quote, the constitutional mandate we announce.
One final question. How are we to determine what the national consensus is based on state court decisions that have struggled, that are struggling to understand what this court has said in
why
Hall
we have to
and
consider
Moore?
the national consensus, but I know part of it.
The state has cited one and only one case in which the court has expressed perplexity, and that is not even a state court. It is a federal district court applying the federal death penalty in the Eastern District of New York. You can look at every single one.
Let me just ask it another way, and then I'll give up.
Well,
how are we to determine?
The
state courts are trying to apply our decisions. And would you deny the fact that that's what they're doing? They're just going off and deciding what they think is the morally appropriate way of dealing with this question? Or are they trying to understand what this court has said? And if they're trying to understand what this court has said, how can that show a national consensus in the sense in which we've used that term in prior death penalty cases?
The state courts have uniformly looked to Hall versus Florida and this court's announcement of its rule in Hall, its two-part holding in Hall versus Florida, and said to determine substantially sub-average intellectual functioning, we look at all probative evidence, including, of course, the test results from properly administered IQ tests.
All right, thank you. Thank you.
Okay.
Justice Sotomayor? Justice Kagan? Justice Gorsuch? Justice Jackson?
Can I just quickly point out that in response to Justice Alito, he asked about whether or not there could ever be a categorical rule that scores alone are enough, are or are not. And I guess I'm just worried about the clinicians and the people who try to evaluate this condition. And they seem to be saying, I'm talking about the amicus briefs here of the American Association on Intellectual Disabilities, that there are, quote, too many variables to consider in determining the validity of each test score and the convergence of that score with other scores and qualitative information to rationally support the use of only one procedure. They seem to be saying that you've got to look at a lot of different things in order to come to the truth of whether or not this person is actually intellectually disabled. It's not enough just as a clinical matter, as a sort of outside of the context of the case. If we're really trying to get to the bottom of this, you have to look at a lot of things. And I thought that was the thrust of the court's conclusion, that you don't cut people off just because they have a particular test score, that you allow experts to evaluate everything and the court to weigh everything in making this assessment.
That is, in fact, what all clinicians believe. But, of course, there are clinicians who would testify, who would, and in fact have testified in Alabama cases, that there was one case, I'm forgetting the name of it, where the test score was 69. There was only one test, it was 69, and the defense's expert witness testified that she did not believe that, taking into account all of the evidence, he was, in fact,
Sure, that's the point of an expert. They look at the test scores, they look at all the information, and they make this determination. So sometimes it's not helpful to have categorical rules that impinge on that assessment.
I think I think we have to be mindful.
Okay, sorry.
Yeah,
you're right. They will boot me for non-engagement.
Members of this court have
also
frequently reminded us
screen, guys, hit like,
that clinicians determine,
share it,
clinical evidence, evaluate clinical evidence,
keep getting
courts
booted.
apply
happened to me
the
several
law.
times.
In this case, we have a law
engaging.
announced in Atkins that someone with this condition may not constitutionally be subject to capital punishment. There is no court that I'm aware of that has simply said there is no there is a well, other than Oklahoma, there is a categorical rule. When and if a court in Alabama or elsewhere is presented with an argument that there should be a categorical rule or that state law incorporates and the Eighth Amendment permits a categorical rule, that will be for the lower federal courts and perhaps this court to evaluate.
Thank you.
Thank you, counsel. Rebuttal, Mr. Overy?
All right, now we are headed back to the
I had a lot
first
of questions
lawyer.
about Alabama
this
law.
Is Mr.
There's
Overing,
no statute in
who is
Alabama.
here for
It's
Alabama.
Ex parte Perkins, and it sets the line at 70. The 11th Circuit understood that at page 35 when it said Smith's claim turns on whether his IQ is 70 or below. Smith's counsel has essentially abandoned that misreading of Alabama law from their briefs because he agreed with Justice Gorsuch that the question is there an Eighth Amendment violation? The United States to prove betray deficient intellectual functioning. We agree with that. The Eighth Amendment doesn't preclude an IQ burden, and 20 states, as amicus, agree with us here. Smith's counsel in the 11th Circuit said that 4 and 5 scores are in the range. Both experts, this is JA 83 and JA 221, used the Flynn effect and then subtracted points for the error range. Both of those are not Alabama law, and they didn't consider the cumulative effect, so the court should reverse. The court should remember that this is not just about state sovereignty, but also preserving the essential function of the jury to make a reasoned moral judgment about the criminal and his crime. The jury here had the very best evidence of his intelligence, his 72, the best evidence in his favor, and what's happened decades since then has only confirmed what the jury knew then, that he is not intellectually disabled. The federal courts now have made the demeaning judgment that those 12 everyday Americans rendered a sentence that was so barbarous as to be beyond the limits of civilized society. No, the court should reverse and give the lower courts no more chances, instruct that the writ of habeas corpus be denied.
Thank you, counsel. The
But
case
cruel
is
and
submitted.
unusual is a legal question, not a fact question. So, okay, so that is case number 1, and we move on to case number 2. Case number 2 is Credit v. Saba. This is a much less engaging case, guys. This is going to be about SEC rules. It's a little bit slower. The real question here is going to be about whether or not there is an implied right of action, which is important because if the government doesn't step in when there's a right of action, can you use it anyway? And this court tends to not think you can. And not just this court. Like the last 20-something years has been like, no, if it doesn't say it, you don't get it. But as the government has been a little bit less likely to use these things lately, we're all nerds, that's why we're here. That is why this is potentially a really big deal and worth listening to, even though we may not care as much about Rule 47B and whether or not it's giving the right amount of protection to underrepresented major shareholders in a BlackRock investment company. But it's all right. But that's why I think it's still worth listening to. I do think this one's going to be a little bit shorter, but I didn't expect that last one to go that long. That was a barn burner. So it is important for the SEC to be doing it. Good point. All right. I just, this is a little bit in the weeds. And this one's actually I think these were major shareholder rights, but still shareholder rights. And the question is whether or not they're enforcing the SEC is enforcing things or not. So I think it is a circuit split, but it's the circuit split appears to be over implied right of action, which is, I don't know. We'll see. There's one of the reliances is on a 1979 case, so that's a weak link because it was not a dead on. It was kind of a tough pull anyway. So, and I do apologize about. I thought I'd fixed the audio, and it is doing that same thing again. So I will figure it out later. For now, every time I see, I'm watching it, so every time it blinks, I'll reconnect it.
We'll hear argument next in case 24-345, FS Credit Opportunities Corporation versus Saba Capital Master Fund. Mr. Dvoretzky.
13 pages of notes.
Mr. Chief Justice, and may it please the Court. To imply a private right of action in Section 47B, Congress would have needed to speak clearly and unambiguously. It did not. Start with the text. Section 47B doesn't come near the high bar for an implied private right of action. Congress knew how to speak clearly to create a right of action, just as it did in Sections 30H and 36B. Congress could have said, an action may be brought by any party to a contract that violates the ICA. Instead, Congress chose language that specifies what remedy is available to parties already before the court.
They did allow it.
Section 47B applies only if a contract is unenforceable. an inherently defensive concept. And Section 47B2 focuses on courts, not who can sue. It uses the term instance, which ordinarily means a request, not a right to bring an action. Indeed, Congress rewrote Section 47B after TAMA, eliminating the phrase shall be void that TAMA had held created a private right of action under the IAA. Statutory structure points in the same direction. It makes no sense to think that, on the one hand, Congress H and 36B, but on the other hand, Congress subtly implied a private right of action for any party to a contract to enforce any provision of the ICA in 47B. What's more, Congress vested the SEC with an array of powers to enforce the ICA, from investigation and rulemaking to exemption and filing suit, which further suggests that it didn't intend private enforcement by implication under Section 47B2. If the court lets the Second Circuit's decision stand, the clear statement rule in Sandoval and Gonzaga will have little meaning. The court should leave private rights of action to Congress and reject Saba and the Second Circuit's unworkable return to the ancien regime. I welcome the court's questions.
By the way, tap your
Respondent
screen,
has quite a different reading of Transamerica than you do. So would you spend just a minute or two
look at my shop,
responding to respondent's argument as to
keep me going.
Transamerica?
Of course.
Transamerica is the 1979
TAMA
case.
Is really the linchpin of their argument. Their argument, as I understand it, is that in Transamerica, the court interpreted void a certain way in the IAA, and that necessarily carries over to present-day ICA. That's incorrect on a number of levels.
Probably true, Shelley.
I agree with them that void was the key language in TAMA, but Congress moved away from that language in 1980 when it amended the ICA. The very linchpin of the court's opinion in TAMA was that the concept of voidness necessarily has customary incidents that let you go to court, including not only to determine the voidness, but also to get restitution. In the ICA in 1980, Congress eliminated void from 47B. It came up with an entirely new construct in B1 and B2. It replaced voidness with unenforceability. Unenforceability is inherently a defensive concept, not one that lets you go to court affirmatively. And then in B2, it introduced court-focused language, focusing on what courts may or may not do when they have a contract before them in a litigation where the parties are otherwise properly before the court. And so whatever one may think of TAMA as to the IAA, it doesn't apply to the ICA where Congress moved away from that language. And in addition to that, a key difference between the ICA and the IAA is that the ICA contains the two express private rights of action in 30H and 36B. And where Congress knows how to write a cause of action explicitly by saying a cause of action, a claim may be brought or an action may be brought by a particular plaintiff against a particular defendant over a particular violation. That strongly supports the notion that Congress did not impliedly leave the door open in 47B2 for an even broader cause of action that would let any party to the contract go in to sue not just over a particular provision of the ICA, but over any provision in the ICA that may be violated.
Mr.
Counsel, we have said in Tutros, in court, in Sandoval, that what we're looking at is whether Congress intended to create a private right of action. You say that neither the text or structure does, but I'm not sure you're leaving out one very important part of the context, which is the statutory history. And that's what the other side relies upon. The IAA and the ICA were passed in the same bill. TAMA then held that identical statutory language in the IAA had a private right of action for rescission. So you're relying on the changes that occurred to differentiate the ICA today, correct?
We're relying on the changes, but I would also note that TAMA was a holding only as to the IAA, not as to the ICA. And
but
so
the language is identical. If this case had come up a year after TAMA, do you think that on the basis of Sandoval, we would have ruled differently?
Well, the fact that the IAA, unlike the ICA, contained no express private rights of action was the very first sentence of this court's analysis in TAMA. And so even pre-1980, there was that distinction that this court, in this hypothetical case, might have focused.
But that difference went solely to the question of damages, not to the question of an implied cause of action with respect to rescission. There is no other claim being made. The issue is narrowed to, is there a right to rescission of an implied cause of action with respect to rescission, correct?
That's correct, but the court hasn't distinguished under the Sandoval line of cases between the standard where damages are sought impliedly versus the standard where equitable relief is sought impliedly.
Well, but Congress has, because what we have said with respect to that statute, the TAMA statute, is that there's no implied cause of action for is one for damages.
That's true, but the distinction in TAMA didn't turn on damages versus equitable relief. It turned on the word void in Section 215 versus different language in 206.
Oh, in TAMA we said that the word void is the power to rescind. And that's exactly the language that Congress used in the ICA in 47B. It says that in the instance of a party that seeks or demands rescission, that it could be given in certain circumstances. So you make much of the fact that Congress did away with the word void, but it kept exactly the meaning of void. It said the insistence of a party to seek rescission.
I don't think it did, Justice Sotomayor. First, because the court said in TAMA that voidness was about more than just rescission. It was also, this is at page 18 of the TAMA decision, a person with the power to avoid a contract ordinarily may resort to a court to have the contract rescinded and to obtain restitution of consideration paid. So,
but it didn't. All it talked about was the TAMA court was only an implied cause of action for rescission, where the subsequent disputes among courts lay was whether that statute also permitted damages. And Congress answered that question in the ICA. It only permits damages in a limited number of cases and not in others. And it doesn't permit it in rescission.
But Justice Sotomayor, Congress also moved away from the word void to the word unenforceable in B1. And I think that's a critical distinction.
Well,
Counsel, can I?
I'm sorry, just one last
Should we
point.
Barrett, maybe?
I know that many of my colleagues don't believe in statutory history, but here we have both a House and a Senate reports accompanying the 1980 amendments to the ICA. And in both the House and the Senate reports, it says that, quote, private rights of action for violations of the federal securities laws are a necessary adjunct to the SEC's enforcement efforts due to the SEC's small staff and overwhelming enforcement. The Senate also wrote, the committee wishes to make clear that private rights of action should be implied to and in its enforcement to the same extent that such causes of action are implied under the ICA. The House wrote, it wishes to make plain that it expects the courts to imply private rights of action under this legislation, where the plaintiff falls within the class of persons protected by the statutory provision in question. I don't know how much more decisive on congressional intent than those statements are. The ICA implies a private cause of action for rescission, and Congress says, what you did there, do here.
Justice Sotomayor, I do think that under Sandoval, the analysis begins and ends with the text and structure, but if I may respond on the legislative history. First, the legislative history also shows that Congress considered legislation in 1980 that would have explicitly added a private right of action, and it didn't do that. So in that sense, the same inference from—
But it did it with respect to damages. It didn't say anything about— it did say about rescission, that at the insistence of any party, a court could grant rescission. Seems to me that what you want us to do is to ignore the statutory context and say that's language that's limited only to parties in the litigation, but they didn't use those words. They didn't say it's limited to parties in litigation.
So I think the term party is best read to mean party to the litigation. When Congress wanted to refer to a party to the contract, it did that expressly in B1. But at the end of the day, it really is not of much moment what party refers to, because, again, the language that Congress used in B1 is a defensive concept of unenforceability, not one that lets you go into court. And in B2, that is court-focused language. It's not the sort of unmistakable focus on an individual and creating new rights, prescribing conduct as unlawful as to that individual that this court under Sandoval and Gonzaga and that whole line of cases has looked to in order to recognize whether Congress meant to create a private right of action. That the text is the ultimate touchstone.
I'd like to ask you a question about your clear statement rule. I don't read Sandoval to necessarily require a clear statement. I understand the question when we're looking at implied causes of action to simply be ordinary statutory interpretation. What do the text and structure require, as distinguished from Gonzaga and our spending clause line? Why do you think there should be a clear statement rule here? And I know the government takes the same position.
So for starters, I think Gonzaga, and this is at page 290, at least as to the first prong of the spending clause cases. Gonzaga, if Congress wishes to create new rights, it must do so in clear and unambiguous terms, no less and no more than what is required for Congress to create new rights enforceable under an implied private right of action. As to why that makes sense, I think it goes to Justice Scalia's concurrence in the Thompson case, which I think is then becomes much of the basis for the Sandoval opinion, where he said that creating a private right of action is such a significant legislative act that there's only a remote possibility, that's a quote, that Congress would do that implicitly. And so before this court, as a matter of separation of powers, reads an implied private right of action into a statute, it ought to look for that kind of clear.
But that would be an innovation. We haven't expressly said that in our implied cause of action cases.
I think you've said it in Gonzaga, and I think it's also.
Gonzaga was a spending clause.
Still Barrett. Oh, is that Kavanaugh?
Haven't we said it in the context of 1983 and whether it secures a right enforceable under federal law, quite apart from the spending clause context?
Right. You've said it under the first prong of the spending clause.
But forget it. We said whether 1983 secures a right for purposes of federal law.
Right. That is the context in which you have equated the two standards. But I think the key point is that you have equated the two standards and that the separation of powers concerns are similar across the two contexts. And
if you might finish your answer first.
No, I think the separation of powers concerns are similar across the two contexts. In both situations, it is the role of Congress to determine whether it is conferring a right and whether that right is privately enforceable.
Thank you.
I had understood that the spending clause context had particular concerns that were relevant to this inquiry. So while we may have said it in the context of 1983, I thought we said it, as you pointed out, in Gonzaga and the line of cases there, in a spending clause context in which we analogized to contracts. And so it was very important to have clarity from Congress in the federal grants context. And that's sort of the impetus of the standards there. Have we said that same sort of thing in this context, outside of spending clause?
I think, again, Sandoval itself really establishes the clear statement rule. That's how this court characterized Sandoval in cases like Gonzaga. When this court was relying on Sandoval and Gonzaga and applying the same standard for both contexts, the court described it as a clear statement rule, as a rule requiring Congress to speak clearly.
All right, so under that rule for this purpose, I'm looking at B2, and you say it doesn't have the kind of party-centric language. I mean, yes, a court may not deny the rescission, but it does say at the instance of any party. And so we do have references in the text of B2 related to parties. Why is that not sufficient in your view?
because the way in which this is written, its primary focus is on what courts may or may not do. In that sense, it's like the Thompson case, where the court said that, I think it was the Parental Kidnapping Prevention Act there, is a mandate directed to state courts. It doesn't create individual rights, even though what those courts may do may have consequences for individuals. This, too, is court-focused language.
Right,
and
but when we're talking, when the right here is the right to bring the action, then a court can't do what it does unless it has an action. I don't understand why it isn't implicit in a direction to a court related to a kind of legal action that the party, as it says here, any party, can bring the action.
It doesn't say that any party can bring the action the way it does in Section 36. It just says at the instance of any party. At the instance ordinarily means at the request of a party, but there are all sorts of things that parties might be able to request from the court once they are already before the court.
I understood that your argument here was that the party can raise it defensively. Is that right? So your point is at the instance of any party in defense. That's how this would work for you?
I think that is right, and that follows from unenforceability.
But unenforceability is in B1, and B2, we are looking at the text here, and it says that the contract has been performed. So we're sort of in a different world in B2. In B1, the contract hasn't yet been performed, and I suppose you could have an unenforceability argument there, but aren't we already in the world in B2 of a contract being performed?
Respectfully, I read the interplay between B1 and B2 differently. I think the only way that you get to B2 is through B1. If you have a contract that has been performed, that can be either full or partial performance. And either way, you need to go through B1 and first show it can be fully performed, but perhaps a contract with a limited term, and there's some litigation afterwards about what happened during the term that has now been completed. It may be partially performed, but either way, the only way to get to B2 is by showing that B1 is satisfied, and that's what the defense of this concept comes in.
Thank you. Justice Thomas, anything? Justice Alito? Justice Sotomayor? Justice Gorsuch, anything?
Unfortunately, I have several questions. I think this case is extremely close. I'll just put cards out there on that. So when you're talking about the statute alone, I get it. But when you look at Transamerica and then you look at the statute, it would be very odd to think Congress has recognized a private cause of action, and then to think Congress got rid of that by explicitly referring to the rescission right that it had just recognized that the court had just recognized in Transamerica. And what the statutory language did was add the unless clause to show that you don't always have a right of rescission. So what Congress seemed to do was say, recognize what the court had just said about rescission, but actually slightly put slight exceptions in there with the unless clause. And what your position would do is say everything goes to state court. And as I understand it, you can respond to that. But in Transamerica, in footnote 8, they address that possibility. One possibility, of course, is that Congress intended that claims under 215 would be raised under state court. But we declined to adopt such an anomalous construction without some indication that Congress, in fact, wished to remit the litigation of a federal right to the state courts. So your theory is Congress comes back in knowing that and refers specifically to rescission, but without giving any indication, does the anomalous thing silently of remitting everything to state court. Now, so that's something you need to answer, and then I'll just get the last thing out, which bothers me, which is the SEC in 2001 and the Bush administration comes in and says, actually, this is an express right of action. I think 6 times in the SEC brief in 2001 says this is an express right of action because it refers to rescission specifically. And so you need to deal with that, and you need to deal with how does this work in state court? You want it to go to state court. Can they bring the suit, the rescission, suit for rescission in state court, and the state court then does what? and why be in state court? So that's a lot. You can deal with whatever you want to deal with there, but those are things that are on my mind.
Let me deal with as much as I can. I think I can distill that to 3 questions. You'll tell me if I'm missing something. One is, didn't Congress just carry over the concept of rescission from the old statute to the new? 2 is, what happens in state court? 3 is, what about the SG's brief in Olmstead in 2001? Does that capture it?
Footnote 8 would be useful too, but
okay, I'll bake that into state court. All right, so starting with the first question, didn't Congress just carry over the concept of rescission? If that is what Congress would have wanted to do, it would have been easy enough for Congress to keep the word void. Void was really the linchpin of this court's opinion in TAMA, and whether or not the opinion in TAMA is the correct result under the Sandoval framework, what the court thought in TAMA was that void had a particular connotation. There were particular customary incidents, I think was the phrase in TAMA, about what void means. And it was that essential term that Congress took out of 47B, and not only took out that one term, it really rewrote the whole structure.
It put in the term rescission. Keep going.
It did put in the term rescission, which can be a consequence of unenforceability, but it came up with this whole new construct that tells you, first, all of this is only triggered when you have unenforceability, which, according to the treatises, according to Corbin, according to Williston, according to the restatement, that is an inherently defensive concept that's a contrast with what this court thought void meant in TAMA, which was you have an affirmative right to go to court.
Sorry, why don't you go to the state court, and how does this play out in state court? I've tried to go through this. It strikes me as very bizarre. Anomalous was the word that the court used in Transamerica. I'll use bizarre to figure out how this would play out in state court and why.
So I think it's a complicated question what happens in state court, which I don't think you need to decide here. I don't think that's what's presented here.
I mean, you're telling us go to state court, not federal court. We should have some idea what's going to happen in state court and why. Why are we going to state court for this?
So I think that if Saba tried to do in state court what it tried to do here in federal court, first, I'm not aware of any state cause of action anywhere that would actually let them go in as a matter of state law and seek rescission in this way. So I don't know that it could ever even, practically speaking, come up in state court. No party has, no party, no pun intended, to this litigation has pointed to any case that is on point for that. If there were such a statute, I think that it would be preempted by the comprehensive scheme that Congress enacted in 47B. Congress intended for there to be uniform nationwide rules about how to determine, about what happens when a contract violates the ICA, and that
I thought you wanted it to be a federal rule of decision.
I'm sorry?
I thought you wanted it to be a federal rule of decision in a state court proceeding, even if brought defensively. No?
So I think this issue can come up in state court in that limited circumstance.
And it would be a federal rule of decision.
Where is a federal rule of decision.
Okay.
But
why don't you go to the SEC brief? Sorry.
So on the SEC brief, I'll let Mr. Schulman address it in more detail, but I think
well, they refer to it as an express right of action.
So first,
or express remedy.
That was essentially dicta in an amicus brief because the case, Olmstead, did not itself even present the question of whether there was a right of action in 47B.
Okay, thank you.
Not the most carefully considered statement by the government.
Really? Okay.
If I might just add.
Do you know that, or you just?
Well, if I might just add, I think they have said that in the wake of Sandoval, which had come out just shortly before that Olmstead brief.
7 months before, I think, but yeah.
But not just Sandoval. This court's cases applying Sandoval and Stone Ridge and the later cases showing that this court really meant something like a clear statement rule.
Thank you.
This action.
Just one follow-up question to Justice Kavanaugh. Play out in federal court in a diversity case. Could there be a declaratory judgment for breach of contract, relying on that state law cause of action?
I don't think there could be. I think for much the same reason that Congress intended this to be a uniform scheme that would preempt state law, it would also displace the ability to bring a declaratory judgment action. It could be used, and in fact is intended to be used, as a rule of decision in federal court if it comes up defensively. In a situation, let's say hypothetically, where a fund has a dispute with the advisor over the payment of fees, And a defense to that could be, well, wait a minute, actually the contract was never valid in the first place, or it's unenforceable because it somehow violated the ICA. That might come up as a defense in that kind of a suit between a fund and an advisor, whether it's in federal or state court.
Is that necessary to your argument? If we think that rescission isn't just a defense, then do you lose on the cause of action point?
No, because even if rescission conceptually can be something other than a defense, this statute doesn't create the right to go to court for all of the reasons that we've been discussing. It doesn't say an action may be brought. It is court-focused, doesn't have the unmistakable focus on creating individual rights that this court's cases require.
Justice Jackson?
So can I just get back to
Robert,
Justice Sotomayor's questions about
it's going way differently than I thought it would. So.
Legislative history. I understand your point about Sandoval and moving away from legislative history in general, but do you agree that Sandoval said that statutory intent is determinative of this issue?
I don't think the intent is determinative. I think the text that Congress enacted is determinative, and obviously—
Isn't that what Sandoval said? Statutory intent, quote unquote, is determinative when it comes to figuring out whether Congress implied a cause of action?
Sure, but there's a statutory intent. So the question is, how is the intent reflected in the words that Congress enacted?
Correct. So, but the goal is that we're trying to figure out what Congress intended, and so I appreciate that some people look only at the text and structure and context to figure that out. But you did, in your argument here, refer to TAMA and the enactment history and the extent to which you think that Congress wasn't incorporating the same kinds of ideas that we indicated in TAMA. So there's something to your argument that is about the statutory development here and not just the text, right?
Well, I think if we never had TAMA, I'd be making the same argument about what 47B1 and B2 means. The argument about TAMA is because I understand and understood from Justice Thomas's first question that is really the linchpin of the other side's argument. They start with that and they say it's carried through. And so I'm responding to that by saying, no, it's not carried through because Congress changed the key language. But even without that change, I'd be making the same argument about what the language that is in 47B means on its face.
Yes, and if we are trying to understand whether it was carried through, you say Congress changed the language, and you say don't look at the legislative history to assess that. Is that your position? Because the legislative history refers to TAMA. It makes pretty clear, as Justice Sotomayor pointed out, that Congress wanted an implied private right of action in this situation, just as we had held in TAMA the year before. So part of your argument does require us, in response to the other side, to close our eyes to that part of the context of this.
So I don't think it does in light of Sandoval, not only because Sandoval says focused on text and structure, but also because Sandoval at 287 to 288 rejected reliance on what it called, I think, contemporary context. So it really is a matter of the text. But, Justice Jackson, understanding that you may wish to look at the legislative history, the other thing I'll say about the legislative history is that the House report and the Senate report that talks about implied private rights of action is talking about 6 different statutes that were all amended at the same time. That's not specific to 47B. The only place in which the reports do specifically discuss 47B, that doesn't mention a private right of action at all. And so this—
So you say it doesn't even get us there when we look there.
This very general legislative history, even if you were to look at it contrary to Sandoval, doesn't bear the weight that it would need to bear here.
Thank you.
Thank you, counsel.
All right, so that's one down, and we move on to number 2. This is Max Schulman. He's here for the DOJ. Whoa.
Mr. Schulman?
Oh, I'm double.
Mr. Chief Justice, and may it please the Court, most statutes fail the stringent and demanding test to imply a private right of action under this Court's precedents. Section 47B of the Investment Company Act is no exception to that rule. Its text does not unambiguously create new rights or focus unmistakably on individual plaintiffs. Instead, it references pre-existing state law rights and tells courts how to limit them after finding a here. while otherwise entrusting broad enforcement authority to the Securities and Exchange Commission. In contrast to those express rights of action, Section 47B simply imposes rules of decision that apply in cases otherwise properly before a court, but it does not implicitly authorize commencement of new federal lawsuits by anyone who alleges that a contract violates any part of the ICA. The judgment of the Second Circuit should be reversed. I welcome the court's questions.
I don't know.
Would you zero in on respondents' argument and use of the Transamerica case?
Yes, thank you. So I agree with my friend that the Transamerica case was focused on the word void in the Investment Advisors Act. That's the key language that it relied on the customary incidence of voidness to imply a right of action for rescission. And that's the language that Congress removed from the Investment Company Act in 1980. So that's not the text that's before this court. And I don't think this court needs to question Transamerica at all. This court has a different statute in front of it, and the post-1980 ICA does not meet the standard to imply.
If it were, Mr. Schulman, suppose that Congress had done nothing on the ICA front. Would Transamerica control?
We think that would be a closer question, but no, ultimately I don't think it would. I think, as my friend mentioned, there are differences between the ICA even before 1980 and the Investment Advisors Act, such as the fact that there were other express rights of action in the Investment Company Act. That's something that the Transamerica Court noted about the Advisors Act. So we think that alone could provide a distinction. And if it,
although there were express rights of action for damages, and presumably Congress is considering both of these pieces of legislation at the same time, their companion bills, the fact that they decided to have damages suits in the one, I don't know. Like, they knew how to do it. They decided to have damages suits in one, not in the other. But what does that have to say about the issue that Transamerica decided?
Well, I agree with what my friend also said, that this court's implied right of action cases have not drawn a distinction between damages and equitable relief, that it's sort of painted with a broad brush in that respect.
But you would really have us look at these two companion pieces of legislation passed at the same time and say that the exact same language has one result in one statute and the other result in another statute, just because there happens to be in one of the statutes private rights of action for damages that are essentially unrelated? That seems like a pretty extreme position, honestly.
So I will say that's a hypothetical question that this court doesn't need to decide. It obviously doesn't have
but it helps me think about it. You know, it helps me figure out, like, what's the baseline here?
Sure. So I'll offer two things in response to that. I think there's another potential distinction between the two statutes, which is that the Investment Company Act is distinctive among the securities laws, even as distinct from the Advisors Act, in how intrusively it treads on core matters of state law about the internal workings of corporations, who can be on a board. And so there, I think there's special reason to think that Congress might not have been treading into areas traditionally governed by state law to the same extent. I also think that even if the logic of TAMA might suggest the same result for the pre-1980 ICA, this court didn't confront it, and this court, its methodology has evolved, and if this...
It's kind of a, it hasn't really. This is several years after Court v. Ash. I think Mr. Clement makes this point in its brief. We hadn't gotten to the rhetorical pitch that we discovered in later cases, maybe. But the court had made a shift already. This was by the exact same people who decided Court v. Ash. This is not an ancien regime case.
So I think TAMA is a transitional case. There are certain respects in which it more closely resembles the modern cases, but it also is relying on some of the bad old days cases, such as the Cardon case from the district court, the Mills case, which was really a follow-on to Borak, the epitome of the bad old days. So I think it's certainly...
Sandoval specifically cites Transamerica in a kind of approving way.
That's true.
Not kind of approving, very approving, several times.
It cites the specific aspects of TAMA that more closely resemble the modern cases, the rule statement at the beginning about how an implied right of action is a question of statutory intent, and then it cites the analysis of the damages question in 206. It conspicuously does not cite the portion of the TAMA opinion that is discussing whether there's a right to rescission.
I'll ask you one more, and then I'll stop. So you said void.
I don't know what TAMA stands for.
You're absolutely right.
And
all the language is void, void, void.
Right now,
but I'm wondering whether the fact that they changed void to unenforceable has to do with just what Justice Kavanaugh was talking about, that they have this unless clause in there. So they basically say, well, not always. It's really unless enforcement would be more equitable. And And once you have an unless clause, you kind of have to change the word void. You know, like void unless blah, blah, blah. It's just not the way we think of voidness, that like you can be void and then discover you're not void. So, so they did change it. They did say not always rescission, but they changed it in a way that actually explains why they had to.
That whatever you think Congress was doing in 1980, it was clearly pulling back from and reacting and saying that it did not want the full consequences of voidness that Thomas suggested. And so we think that's a reason to suggest that it clearly was contemplating that more of these contracts would be enforced. And certainly that, I think, dovetails with our argument that it also doesn't pass the clear statement to imply a private right of action. I think there's an important distinction, too, that the 1980 amendments also amended other provisions of the Investment Advisors Act, but did not amend 215 in the Advisors Act, the key provision in TAMA, which still says void. So I think that's just a very strange way to think that Congress was ratifying the intent, the decision in TAMA as applied to the ICA. If anything, I think that it suggests that Congress was perhaps acquiescing in that result as to the Advisors Act, but saying, no, we don't want that result in 47B of the Investment Company Act. We're moving away from that.
What can happen in state court now, under your view?
So I think all parties agree, and we do too, that it could at least be raised defensively. The parties.
Can it be, the at least is important. Can it be raised more than defensively in your view?
So we are agnostic on that for purposes of this case. We agree.
Well, that's a pretty important thing to be agnostic on.
Well, so
you don't have a view on that, how it's going to play out in state court?
So I agree with what petitioners say, that the cases that have been cited in the briefs, we haven't seen a case brought under a state law cause of action, even in the circuits that have not allowed.
Well, you will soon if you prevail here.
I think that's a fair question, but the Third Circuit has barred a private right of action under 47B2 since 2012, and we haven't seen cases in that.
Except there is a question, which is federal law trumps state law, correct?
Certainly.
And what you're suggesting is that Congress thought that it was the right of the state to permit bylaws that violate the ICA, unless you go to court to challenge that practice.
Thanks, Marie.
So meaning you, the government.
We do think that the SEC is the primary enforcer, and that's important.
I agree, but what you're suggesting to Justice Kavanaugh is that respondents are barred from going to state law for a declaratory judgment rule. They could go to state law and say, this permissible bylaw under this state's rules violates federal law, and federal law trumps.
So we actually haven't taken a position on whether a declaratory judgment...
I'm pushing you the way Justice Kavanaugh did. Well, do you really think that Congress intended in this language change to permit states to let companies do what they wanted with respect to voting rights and do it until the SEC acted?
So I do think that Congress intended for the state law remedies or causes of action available to be in the first instance where parties should turn. And I think that, whatever else the 1980 amendments
State law should be where they should first turn. So they go to state law and say, declare this bylaw invalid under federal law. Can they do that or can't they?
So I'll just say respondents here are asking for rescission. I don't think that could be provided in a declaratory judgment action, so that's all you need to decide this case. To the extent there would be a hypothetical question about a declaratory judgment action, the complaint in this case at PEDAP 36 suggests...
I don't know what else void means but that.
I'm sorry.
Please finish.
That there is not complete diversity among the parties in this case, so I don't think that would be available here. In another hypothetical case, it's possible, but certainly the Declaratory Judgment Act just gives courts discretion, and we think it might not be appropriate for courts to exercise their discretion. But we think that's an issue that this court can leave for another day.
I have a question, Mr. Schulman, about how you understand the scope of... I'll ask in my round-robin time.
No, please.
How you understand the scope of the cause of action that would be implied here. As I read TAMA, it was a pretty narrow cause of action because the court said it was apparent that the two sections were intended to benefit the clients of investment advisors and parties to advisory contracts. Do you understand the cause of action that respondents are seeking here to sweep far more broadly than that?
Cage.
I do think there's potential that it could. The parties in this case have a disagreement over what party means. We don't think that's dispositive, and I understand petitioners to agree with that. But I do think there's potential that Congress could have thought this would be disruptive to allow, and that's potentially why it made that change in 1980 to the extent this court.
Because it could be any contract. Putting aside the party's point, it's not just focused on a particular kind of contract or a narrow beneficiary of a particular statutory provision.
That's exactly right. Yes, Your Honor.
Thank
Christoph?
I want to figure out exactly what we're talking about when we're referring to the ancien regime. It seems to me that can be understood in two different ways. One is if you have a court interpreting the statute and relying in its interpretation on materials that would not necessarily be relied on today, the legislative history. I understand that you don't say, well, we're going to start all over again and reinterpret that statute. But if you have the statute come before us today, the fact that there's legislative history in it and that the statute was passed back is to look at the text of the statute rather than what some legislators from some houses of Congress may have thought about it. So that's not, the fact that the statute comes from before Sandoval is not a license to look at what legislative history. All that means, as I understand it, is that you don't go back and reinterpret a statute you've already interpreted. Is that your understanding?
Yes, absolutely. And I think Sandoval says that the court will not revert to the understanding of implied rights of action that was prevailing at the time the statute was passed. This court applies its current methodology to the cases that come before it.
Thank you. Justice Thomas? Justice Alito? Justice Sotomayor?
Sorry.
Yep.
One more.
The SEC brief in 2001 referred to it multiple times as an express remedy. Disagree with that?
We do. As we say in our brief, we've reconsidered that position in light of this court's developing jurisprudence. And I don't think that's the theory on which the Second Circuit ruled either. The Second Circuit said that there is not an express right to sue in 47B. And so we just think that the way this court analyzes these statutes now, it does not provide a right of action.
He was stuff on the side
You
of the mic.
mentioned that the SEC can grant exemptions, and that would create confusion in your brief, right?
We do think there's the possibility of that. I do want to say we are taking this court at its word that text and structure is what matters, so we're not making a policy argument that you should decide on that basis, but we do think there's a possibility of that.
Okay, but if there's state court actions, those SEC exemptions and the certainty that would grant would be out the window anyway, whether it's state court or federal court, and you being agnostic on the state court thing means that argument really just drops out entirely then, unless you want to take a position on that.
Well, so I'm not sure that that's right about exemptions. The parties don't really get into this, but I think it's at least possible that an exemption granted by the SEC is not a simple forbearance from prosecution. It's granting an exemption from the requirements of the statute that I think could apply in private action as well. So we don't think it would necessarily undermine exemptions in that way. The Yahoo litigation is an example of litigation over the scope of an exemption, but I don't think the parties were arguing there that the exemption was not a shield in private litigation.
And from your perspective, the Second Circuit's had this rule for about 7-ish years, I think, 6 or 7. There have been problems in the Second Circuit with the rule.
So there have been an increasing number of suits invoking this private right of action that we've seen. As I say, we're not primarily relying on disruption, but the amici do point to things that from their perspective are disruptive, and we think to the extent this court is concerned.
Well, how would you characterize, is it disruption just meaning illegality in the contracts as being the subject of the suits, or what's the disruption?
Well, so I would say the disruption is that the SEC is the primary regulator in this area. It's in communication with regulated parties. It brings enforcement actions. It has informal communications with parties. And then for private parties to come in and seek to upset these contracts that the SEC is aware of from these registered investment companies, we don't think Congress anticipated that necessarily.
Thank you.
Justice Barrett? Justice Jackson?
Is there any daylight between you and Mr. Dvorsky?
I don't think we disagree on anything necessary to decide the case. As I was attempting to say earlier, we haven't taken a position on the argument in petitioner's reply brief about whether there would be preemption of an affirmative state cause of action, but I don't think this court needs to reach that to decide this case.
Thank you.
Thank you, counsel. Mr. Clement?
Mr. Chief Justice, having heard the argument to this point, let me emphasize 3 points.
think this is an implied cause of action case at all. There's express text here. There's about 150 words in 47B. And the question is, what's the best reading of that statutory text? I think if you look at the actual statutory text, it becomes clear that Congress couldn't have possibly wanted to get rid of the rescission action it would have understood there to be in the shall be void language. In B1, it adds not just the word unenforceability, which if that were it, might be different, but it says unenforceable by either party, which is very close to a synonym to void, and probably the reason that Congress used the synonym and not void is precisely the one Justice Kagan suggested, which the unless clause looks a little uneasy with the word void, but works better with unenforceability by either party. But in all events, B2 uses rescission by any party, so it makes it express. That's why the SEC had this exactly right in the Bush administration, that this is an express cause of action case. And then B3 should not be ignored either, because it addresses two secondary questions that can arise with a right to rescission, namely severability and whether you get unjust enrichment. Now, I know better than anybody that not everybody at this court likes to look at legislative history. But if you're going to look at anything, look at what Congress said specifically about adding this particular provision. And that's on page 27 of the House report. The identical language appears at page 10 of the Senate report. So you have bicameralism without presentment. What it says these words are meant to do is they, quote, they are designed to provide clearer statutory guidance in interpreting that equitable rescission remedy. They are talking that equitable rescission remedy is their reference to Section 47. So it is crystal clear, if you're going to look at that report, that they were not trying to make the rescission remedy go poof. They were trying to refine it. And the last thing I was going to say is this is a weird case, because all three parties agree that this language does more than just create a statutory right enforceable only by the SEC. The only question is whether it weirdly or anomalously, to use the footnote 8 term, is only enforceable in state court or whether you can bring it directly in federal court. I welcome the court's question.
What would a state law action look like where you could raise it as a defense?
Boy, I have no idea, but let me speculate, and that's all I'm doing is speculating.
Speculate wildly.
I think, for starters, we could probably just go in and say we have a common law right to bring an equitable rescission action. I can cite sort of story on equity, that just in the old equity courts, you could go in and demand they bring a deed in or a contract in, and you could seek rescission of it. So if federal law provides sort of the substantive law for the vessel of that equitable rescission action, which is what I thought the government was kind of at least not foreclosing. I mean, I think that's one way to do it. Obviously, the at least language is right. We all agree that you could at least raise it as a defense in a breach of contract action. But keep in mind, that'd be a very weird thing for Congress to go all the trouble of saying that in this context we care enough about compliance with the Investment Company Act that we're going to expressly use the words rescission by any party. But the only time you can bring it is as a defense to a breach of contract action, which in this context would mean an action where the fund managers actually go to the trouble of suing their own shareholders for breach of contract. Now, as far as we can tell, that essentially never happens. And the whole point of the Investment Company Act is to protect the shareholders against fund managers who have all kinds of bad incentives, like in this case where they say, you know, if you get more than 10% of the shares and you're going to tell us that we should do things differently and get this fund to be closer to net asset value, well, guess what? Anybody over 10%, you don't get to vote anymore. I mean, it's a clear violation of 18I of the Investment Company Act, so there's no way the fund here is going to sue my clients for breach of contract. So under their theory, this language that Congress went to all this trouble to add is basically nugatory.
Counsel, you cited the House report, and then you said this is what Congress said. Did Congress pass the House report?
Of course they didn't, Your Honor, and obviously a little bit loose in that language, but not everybody looks at House reports and Senate reports. If you don't look at them, just ignore it. Yeah. But if you ever look at these, when you have the same language in the House report and the Senate report, and they're explaining what they're trying to accomplish by the changes to this precise provision. My friend on the other side said there's the language that we were talked about that's about a page later in the House report and the Senate report that says that the Congress of 1980 liked implied causes of action more than the court in 1979 liked implied cause of action. I don't think that's the language to focus on. It's helpful to us. But the critical language is a page before where they say what we are trying to do, And the we here is the House and the Senate, not Congress. But what we are trying to do here is to provide clearer statutory guidance in interpreting an equitable rescission remedy.
And why do they need? Go ahead.
Michelle, notice the dark circles under my eyes? That's because they've been going for 3 days.
Because you usually advocate statutory history. But this an individual legislator at a hearing or on the Senate floor making a statement, correct? This is the Senate and House reports that accompany the bill.
That's exactly right.
All right. Now, to the extent, isn't there a difference between citing to something like that as opposed to citing to ad hominem statements by senators at a committee hearing somewhere else?
Totally agree. I mean, there is, for those that look at it, there's a hierarchy of legislative history, and House reports and Senate reports are towards the top. But I do want to be clear that I read every member of this court as being willing to look at not legislative history, but statutory history. And the evolution of a statute. And indeed, Justice Scalia, who didn't like legislative reports, even House reports very much, one of the things he looked at is kind of the evolution of a statute, and he found, this is the Gwinnett County case, another case where he favorably cited Tama, if you're trying to keep track of that. And in Gwinnett County, he dealt with a situation where the text of the statute didn't have an express cause of action, but Congress, in a later statute, expressly waived the state's 11th Amendment immunity. And what Justice Scalia said in that case is, uncle, you got me. I mean, at the point that you're addressing secondary questions that presuppose the existence of a cause of action, even if there's not an express cause of action, I'm going to agree that there's a cause of action.
That you can look at the statutory context to figure that out.
Can I take you back to the language?
Sure.
So I start from the baseline that if Congress had done nothing and we had decided TAMA, we couldn't reach 2 different results on the same statutory language. But in fact, Congress didn't just leave well enough alone. It changed a lot.
If you're in the YT.
And whether you're going to say, the void is the question, or, I hate to be simple-minded about this, but there is a lot of red on this page when you do a red line of the TAMA provision and then the as-amended provision. And I wonder whether that just doesn't take TAMA out of the picture and say, now we just look at it in the standard way. We say, is this language enough to be rights creating?
So I think if you look at it without TAMA, there's still enough there to say that there is an action. So I want, but in terms of the red line, there's a lot of red, but it's all like red addition. It's not struck out. The 3 words are struck out, shall be void. And they're replaced with 120 words that tell you all the details about how this rescissionary action is going to proceed. And the unless clause is a qualification that wasn't there, but it's a qualification that presupposes that you can get into court for a rescission. In fact, B2 is kind of written in this backwards way, which sort of assumes that the rescission is being asked for by the plaintiff, and the court shall not deny rescission unless it makes a finding. And if you want to really get deep into the weeds of this, if you trace back the proposed language here, it goes back to a proposal that was a sort of model approach to securities law by Louis Loss. And it originally said in something like B1, it said defendant, and in B2 it said something like plaintiff. And in all events, then you get to B3, and B3 answers the kind of second-order questions that Congress answered in the Title IX context when it said, we're going to waive the state's sovereign immunity. It says,
I guess what Justice Kagan's getting at is, all right, when Congress says we waive sovereign immunity or whatever, it's pretty hard to get around that, right? This presupposes that there is a cause of action. But here the red line takes away the words shall be void and does a whole lot of other things. And that implication is not inevitable at that stage. And then it really is asking us to take one last drink. Thoughts?
Thoughts. I think it is, once you get to the language that they added, 120 words they added by my rough count, they all presuppose that there is a rescission remedy available at the instance of any party. And I do think B3 are the functional equivalent of waiving sovereign immunity. You're basically answering the question of what are we going to do about the severability of the valid provisions of the contract from the invalid provisions. And oh, by the way, B2 talks about partial performance. So there are going to be some situations where you rescind a contract that's been partly performed. And then the question is, if you got some benefit from the partial performance by the side that you're now rescinding the contract, do they owe you like $100 for mowing your lawn under quantum merit? And the answer is yes, you get that unjust enrichment.
I appreciate it. There are interesting complications, some of which are befuddling. But it is not the unmistakable, there has to be a cause of action, because otherwise you don't waive sovereign immunity from it. And in fact, the language that we relied on.
But it's functional.
Okay, it's
from what I learned contracts.
Is that our test? I mean,
when I learned contracts, I was told that unenforceable by either party meant void. Okay, that they were the same. And that was different from a voidable contract that was only voidable by the party, like the infant or the minor or the orphan, right? So I don't think Congress changed this language in any material respect, except they added the unless clause to both B1 and B2. And they're providing a little equitable play in the joints. But that makes no sense unless there is a rescissionary cause of action.
Jolie,
and then you get to the rescission by any party, at the instance of any party. And if
that's added too, right? I mean,
that's added too, and the Latin root for that tells you that's like not just at the request, that's the initiation by any party. So, I don't know if you want to go all the way back to Hale and the ecclesiastical courts, but I think any fair reading of this, whether or not you look at the House report or the Senate report that tells you exactly what they were doing, but any fair reading of this text.
Why do you think,
I'll remember that next time.
Why do you think they phrased it this way, though, at the instance of any party? I mean, that's your hurdle, I think. I mean, it also helps you, but the hurdle is it's phrased, in the language of the court. A court may not deny rescission at the instance of any party. And so it's kind of an odd phrasing, I think you would acknowledge. Why do you think it came out that way?
I think it came out that way. I mean, again,
What's a theory?
The honest answer is it was based on this Louis Loss's model security language that had something like this, and it made a little more sense the way it was originally written, because B1 was a pure defense by the defendant, and B2 was rescission by the plaintiff. And as sometimes happened, they modified the words a little bit, and maybe something gets a little clouded, but I don't think it really gets clouded. And let's say this for starters. If you were trying to say that this is only a defense that can only be raised by the defendant, the worst phrase in the world would be rescission by any party. I mean, because that makes it clear, like it's the plaintiff or the defendant.
How does that play? I think I agree with what you just said. How does that even play out, do you think? I mean, we're getting back to the state court action. But.
And I'm glad you asked about that, because, by the time my friend is done explaining how this is going to play out, if you don't have a federal cause of action, by my count, he's got implied preemption kicking in, so much for textualism. But then I heard today for the first time that there's somehow going to be like implied displacement of the Federal Declaratory Judgment Act in a case where there's diversity jurisdiction. I mean, the circus music is playing over here, and you avoid all of that, all of the anomalous result from footnote 8, if you just say, hey, this isn't that big a deal. You go in, and keep in mind, whatever you decide in this case, you are going to be able to go into federal court under an equivalent action under the Investment Advisors Act and the Exchange Act. It's not just TAMA, it's 29B of the Exchange Act, which has the same shall be void language, happens to actually Congress in 1938, 2 years before it passed these statutes, it added a statute of limitations to shall be void language, making clear beyond all cavil that that was a cause of action. And I think you have the similar thing here. By the time they add B2, by the time they add B3, you can only understand.
Do you understand their implied preemption thing? What were they talking about there?
I think they were talking about the fact that once you were in state court and you raise this as a defense, it is a uniform nationwide federal defense that would displace any state law that sort of got in the way of raising the state defense. But again, to me, when they're trying to get up here and bang the table about, text, at the point they're relying on implied preemption to make things sort of work in state court, I think they've lost the theme, The theme is look at the text. I think this is an easy case after Tama for the reasons we discussed, but I take this text straight on, and this text, rescission at the instance of any party.
But Mr. Clement, any party, if it refers party to the contract, then it's not crazy language to use. I heard you say to Justice Kavanaugh that would be the worst language to use if it was a defense, and I assume that you meant because you're thinking of parties to the litigation? Or did I misunderstand that?
No, I think either way, it's the worst language if what you're saying is it's only a defense. Because then you would say rescission by the defendant or rescission as a defense. You wouldn't say rescission by any party.
No, but what if it's party to the contract? Rescission by either party who wants to get out of the contract as opposed to party to the litigation.
But again, you would say rescission by the defendant or rescission by, as a defense. You wouldn't say rescission by any party. Rescission by any party sort of suggests that either, both principles to the contract could raise the issue. And so I just don't understand if you were saying it's only a defense. Why would you say rescission by any party? Especially because, keep in mind, and I'm going to give you an old chestnut here, Ward against Sherman, a 1912 case from this court, which described rescission as an affirmative remedy. So, the idea, and this court said as much in Tama, without citing my chestnut, that in Tama, we could say you can raise voidness or rescission as a defense, but we've never thought of it as being only a defense. The customary incident of voidness includes an affirmative right to rescission. And one way to think about this, and the way I think about this, and I think it's the way the SEC was thinking about this in 2001, is Tama finding an implied right to voidness, to the incidents of voidness, which include rescission, which requires a little bit of implication. I think after 1980, we're out of implied cause of action land. We are into express textual references to rescission by any
express cause of action in the ICA, though. What about, and that's a difference between this and the IAA and Tama, that there is an express cause of action in this statute.
Remember, the party that was resisting even an implied right to rescission in Tama raised sections 30 and 36 of the ICA, and they also raised some other express causes of action and other provisions of the securities law. And they said, this shows you that when they want to do an express cause of action, they know how to do it. And that didn't deter the majority in Tama, which of course included Justices Rehnquist and Justice Powell, from finding the rescission remedy. And of course, that decision, there's the transition from yes, we're finding a rescission remedy to no, we're not finding a damages remedy. And the court says it's quite different. So in Tama, they expressly considered the same causes of action for damages, and it didn't in the ICA, and it didn't stop them from inferring a rescission remedy in the IAA. And now, my friend will tell you, well, yeah, but this time that they're the exact same statute. But that makes very little difference in the context of these two particular statutes, which were passed the same day in the same act of Congress. And so, and indeed, if anything, the argument that was kind of made in Tama is, look, the Investment Company Act, they wanted some remedial stuff because they had these two damages actions, so they probably would have been more forgiving of wanting rescission action. So I just don't think you can get there from that. I think Tama got it right on the rescission, but it was by implication. I think after 1980, it's no longer even by implication. And that's, I think, what the SEC was saying in 2001 when they said, and, dictum, I don't know, amicus briefs had dictum, but they said it 6 times. So it was a pretty considered position. And by the way, it was all in service of getting the Second Circuit not to come up with an implied damages remedy. The SEC told the Second Circuit, you don't have to do that, because there is an express
That's the same as Tama then, right?
What's that?
That's the same as Transamerica. Don't have the damages remedy, just have the rescission.
Yes, exactly. And I will say this. I mean,
they were 9-0 on the rescission, 5-4 on the damages.
Exactly, right? Exactly.
But can I, keep going, sorry.
Yeah, I'd just like to make this point about this, which is, there's a huge difference between a damages action, which is going to attract all sorts of litigation, and a rescission action, which is about the most targeted kind of relief you can get. And there just isn't a lot of money in most cases in rescission.
Well, but this is what I was going to ask. The amicus briefs say, if we agree with some of the amicus briefs on the other side, in addition to petitioners in the SEC, I think use phrases like chaos, disruption, kind of toss those around. So I want to, you know.
I'm glad you asked. So let's start with the last 6 years in the Second Circuit, okay? I eventually want to talk about history going back to the Exchange Act in 1935 and the.
Let's just go to the last 6 years.
Let's just go to the last 6 years. Now, I would say in most circumstances, just 6 years in one circuit, not that big a deal. But in a financial case, 6 years in the Second Amendment, in the Second Circuit is Freudian. 6 years in the Second Circuit is a long time. And I looked at those amicus briefs, and I actually tracked down what's happened in the Second Circuit. And as far as I can tell, there's really like two sets of litigation. There's the litigation my clients are bringing, and I think we're on the side of the angels trying to liberate shareholders and increase net asset value, okay? So I'll defend those to the end. The other cases I found, there are 3 cases they cite that involve challenges to SPACs, okay? Here's what actually happened in those cases. Those 3 SPACs raised a bunch of money thinking they had some great new idea, and then that idea sort of petered out, and they hung on to their money for 18 months. And at that point, somebody said, geez, this looks like an unregulated investment company because they're holding on to all this money for purposes of investment. They haven't done anything with it. And so they brought that action. The SEC, I think it was in the last administration, but the SEC looked at it and said, yeah, actually, this is a problem. And then they created a new rule that says you basically have an 18 months when you have a SPAC before you need to actually take those funds and invest them. Otherwise, you either got to give the money back or you got to satisfy all the requirements for an investment company. And then those cases settled favorably to the plaintiffs. And that's it, as far as I could tell. That's the floodgates have opened. And I think the reason for that, and then of course, we've had rescission actions under the Exchange Act since 1935. I don't think there's been a moment under the Exchange Act where courts didn't think there was a cause of action for rescission under the Exchange Act. In 90 years, floodgates have not opened. Now, why is that? Because there's just not the same money in rescission that there is in a damages action. And by the way, rescission is of the contract and you knock it out. Now, there are circumstances like this case where doing so is incredibly important, but it's just not going to attract the plaintiff's bar or this flood of cases.
Does that make it any more acceptable for us to imply a cause of action? Does it matter? Do we have any more power to imply a modest cause of action as opposed to a substantial one? And if so, what standard do we use to tell the difference?
So I don't think at the end of the day it makes a difference. I don't. But I'm asking you to exply. I'm not asking you to imply. I'm just asking you to read
your brief
the text
says it's one thing to imply damages and it's another thing to imply rescission. It's right out of your brief.
Yeah, and I think that fairly describes what the court was thinking in Tama.
But I'm just asking you, is it your position that you think it's okay to imply rescission but not damages?
I don't actually,
okay.
but
I wouldn't. I'm glad to hear it.
But I do think there are circumstances we're looking at the same text.
No, I understand your argument about text.
Okay. And I do think, but I will say this: I don't think it's okay, but it is less disastrous to do it. I mean, because I do think, particularly with the rescission,
less disastrous for private litigants, perhaps, but pretty disastrous for our system of government where the people are supposed to write the laws that govern them, not judges.
Yeah, I get it, but
you get it? The separation of powers might be disastrous.
No, I get it. But look, at the end of the day, look at their position. They have the same separation of powers problems, and now they have huge federalism problems because they admit this isn't the normal.
I'm talking about implied causes of action, and it seems to me you've acknowledged that it would be bad, not okay at least, for us to imply any cause of action.
And you don't have to do it here.
I got you. Because it refers to rescission, right? I mean,
it does. Rescission by any party.
Rescission's in the text.
Right, this is not a one last swig. This is, look at this text. This text says
you
rescission.
So it's a federal court, state court issue as I see it. Like this is going to happen. It's just going to happen in federal court or state court. Now they cite Thompson a lot. So you need to respond to Thompson. Obviously that's on the kidnapping, child custody situation, state courts. Deal with Thompson.
Please. So first of all, can I start with the dissent? Justice Scalia, Thompson, another case where he cites Tama favorably in his, it's a concurrence. It's a concurrence, sorry. Yeah. But he cites Tama favorably in the concurrence. Now, I wouldn't overread the majority opinion in Thompson. Thompson is a majority opinion.
Thompson, yeah.
Thompson, I would not overread the majority opinion in Thompson because Thompson finds no cause of action in the Parental Kidnapping Act, and it's an easy case. I mean, the majority opinion is written by Justice Marshall. Talk about sort of the anti-Scalia when it comes to being comfortable with implied causes of action, but even he doesn't find one in the Parental Kidnapping Act. Now, here's why. That statute was passed as essentially pursuant to Congress's power to implement the full faith and credit clause. And in that context, a statute that is addressed to the courts is almost certainly assuming that you've already got a judgment under some other cause of action. And the question for the courts is, should the courts give full faith and credit to that earlier action? And in that context, to try to go into court and affirmatively use this full faith and credit statute to have a cause of action, an initial cause of action, is a complete misfit. That's why it's 9-zip against that. But I think it would be a huge mistake to say that a provision directed to the courts is somehow a strike against something being an express cause of action. Because actually, if you're thinking not about the questions under 1981, where 1981 provides the vessel, and this is just a statute that affects individual rights, when you're actually talking about something that may very well be, and in my view is, an express cause of action, it's not at all anomalous to refer to the courts in that, because the courts are the ones that are going to administer the cause of action. So it doesn't make any difference whether you say the courts shall not deny rescission unless, or if you have, say, a party has a right to rescission in court unless the court, they're the same thing. So it is a strike, and I don't want to be misunderstood about this. Like, it is a strike against a statute in the 1981 case if it were directed to the courts and not to the private party. But when you have something like this, where the question is 47B an express cause of action, then the fact that it talks about the courts is not a strike against it. It's pretty normal to say that an express cause of action is going to be directed to the courts. The courts are the ones that are going to apply it. And let's hope it's the federal courts. I mean, I have to say, at the end of the day, I think if my friends on the other side win this case, but win it on the grounds that all these things have to go to state court, they're going to rue the day. I mean, from the perspective of what they care about, disrupting the SEC's enforcement actions and all of that kind of stuff, the one thing worse than having the occasional rescission remedy in federal court is going on and interpreting the investment company basis. And that's the world they envision. Or, in fairness to petitioners, what they really envision is that they're going to interpret this into nothing. And so all this 120 words about rescission by any party is never going to happen because no investment company is ever going to actually go to the trouble of suing its shareholders for breach of contract.
One comment more for petitioner on rebuttal, but I'll get it out there, is that Thompson does make clear that in the context of custody determinations and full faith and credit, it's a mandate directed to state courts, which, I'll just throw that out there.
Yeah, no. And again, in the full faith and credit context, which is a very specific context where, you're telling the courts what their directions are about giving sort of credit to judgments that you assume have already happened in some other court. And in that context, it's custody. So, of course, it's going to be state court. But again, that argument that was made there was a 9-0 loser in an opinion written by Justice Marshall. That's not the edge case that tells you how to interpret every other statute.
Mr. Coleman, I thought it interesting in the amicus brief for the securities law scholars looked at the historical context, and I don't know to what extent to all of us, but it looks as though this language, even the void, and they say even the amendment, really mirrors or tries to incorporate the state blue sky laws. And the sort of pedigree of this is that everybody really understood that a private right of action was necessary in this kind of context for a rescission in order to aid compliance with the state and federal securities laws in this way. So it was sort of like the background under which these types of provisions came into being. Do you agree with that?
I agree with that. I think that is a very helpful brief. I mean, not everybody's going to give it full faith and credit, but I think it's a very helpful brief. And I think the point at which it becomes most helpful is when they sort of explain the transition from the state blue sky laws to the Exchange Act of 34 and Section 29B. Because that's the first statute that used the shall be void language.
Securities
and of course, everybody kind of understood, and it was quite, if I can finish, it was quite uncontroversial that 29B created a right to rescission. And that's just the same language that carried over into the Investment Advisors Act and the Investment
Thank you,
Company
Counsel.
Act.
Justice Thomas?
Oh, Shelley.
Justice Sotomayor?
It's like my dream job.
Kagan? Gorsuch?
Somebody will give me
Kavanaugh?
a robe
Justice
one of these days.
Justice Jackson? Okay. Thank you, Counsel.
All right, now we are back to
Rebuttal, Mr. Tvorevsky?
Thank you, Mr. Chief Justice.
Tvorevsky.
I think the colloquy here today shows that this is about the most roundabout way that one could write a cause of action. If Congress wanted to create a right to sue here, it could easily have specified who can go to court, for what, whether it's for damages or for rescission, against whom. It didn't do any of those things in this statute. And so what was Congress possibly concerned with here? One thing, we know Congress was concerned with the level of enforcement and with where it was going to happen. We know that because Congress pulled back on the rescission remedy by adding the balancing requirement and the severance requirement, and that shows that Congress was concerned about over-enforcement. Congress in this statute made the SEC the primary enforcer of the ICA. It also allowed the SEC to grant exemptions, which again shows that Congress was concerned about over-enforcement. What Congress didn't try to do in 47B2 was create a backdoor cause of action that would allow anybody into court, any party, to sue over any violation of the ICA anywhere. With respect to Justice Sotomayor's question about how investors could be trapped under these impermissible bylaws, one, again, the SEC has taken positions on that issue. And depending on the presidential administration, it's gone both ways. So it's the SEC that's the primary enforcer of that. With respect to my friend's comments about closed-end funds, we're actually the ones who are the angels here. These closed-end funds are ones that provide a reliable and important long-term stream of income for retirees. And the strategy on the other side is to acquire a significant share, go in, change the investment strategy of the fund, and then cash out. That's precisely one of the things that Section 1 of the ICA says that Congress was concerned about when it passed this statute. With respect to TAMA, I do think that even under the pre-1980 version of Section 47B, this court today would look at that and reach a different result. I think TAMA, as my friend from the government said, characterized it as a transitional case. The standards up at the front of the opinion, which are what Justice Scalia latched onto, the 206 analysis, spot on. The 215 analysis, reading a lot into void, relying on Mills, which was an ancien regime era case, relying on legislative history, not so much. So I don't think that the court would read the statute today in the way that TAMA did. But critically, again, Congress changed the key language that TAMA relied on. The three critical words are gone from the current version. With respect to damages versus injunctive relief, Sandoval itself involved injunctive relief. The Armstrong case later involved injunctive relief as well, and the separation of powers concerns are the same. Justice Kavanaugh, with respect to what happens in state court, just to clarify the point about preemption, again, I don't think you need to decide this here, but I think what would be preempted is an affirmative cause of action under state law to seek rescission. The reason that would be preempted is that Congress created a federal rule of decision, and the mischief that would result, I think, is illustrated in particular by the Yahoo case in the Ninth Circuit, if you wanted to look at that.
Thank you, counsel. The case is submitted.
All right. That's it. Okay. Whew. All right, where are we? We're at 3 hours and 30 minutes, guys. So anybody who's been here all day, mazel tov. Okay, so let me run back through. First, real fast, we're just going to say hi to that because you got to take a second for that. And yeah, girls, sorry, everybody who's been here. That's, speaking of people with, or dogs with stamina. Okay. I want to back up. Should I do this in reverse order? Yeah. So I want to go back because that was a lot more interesting than I was expecting it to be honest. And particularly Kavanaugh right out of the gate saying that it was a close case surprised the heck out of me. I did not expect him to I was expecting this to all kind of be on one side, and for him to come out of the gate and say, "This is really, we're kind of torn here," was a bit of a surprise. And they bring out the legislative history. Oh, specifically, what was the wording? They drew a line there between, and I want to use the words, the statutory history and the legislative history. So, okay. There was a time, the primary goal of interpreting a law, the main goal, is to figure out what the legislature intended when they wrote it. Mend ethices, I would say read the thing. Oh, it's gone. Hold on. Let me bring it back up. Because it's going to be hard for me to keep a thing going in my head as it is. And so one of the kind of ways that the court has done this in the past, try to figure out what's going on, is to look at the history of when it was legislated, to look back at what the legislature did, what was written down during the legislature deciding to pass it. And for a long time, legislative history was considered kind of the best thing we could use to figure out what the legislature was thinking when they passed this law. What did I say? Oh, wrong case. Did I hit the... Oh, whoopsie. Thank you. Sorry. There we go. Actually, I'll switch it to... Paul for... Yeah. And after some time, it was decided that legislative history was a bad choice. And the reason was that, let's say we have 100 people in a legislature, in some imaginary legislature. And as we're trying to figure out which way to vote on this thing, 3 people get up and give speeches on which way we should go and which way they should vote. What it says in those speeches may be our legislative history. We may be able to go back and look at those speeches and get some sort of sense of what was going on. But we're really only going to get a sense of what those 3 people thought. There is somebody in the audience or in the legislature who made a decision that may have had nothing to do with what any of those 3 people said. And we have to acknowledge that is, that people aren't binary, that they didn't just say, yes, I'm going to vote this way because of what this person said, or I'm going to go this way because of what this person said. There might be other things going on in their heads. And so that's why we've kind of moved away from using legislative history, because it doesn't really tell us what was going on in everybody in the legislature's heads when they decided to vote for or against this thing. So that's why we've kind of pulled away from legislative history. However, sometimes the legislature actually leaves us a really specific kind of set of instructions and says, hey, just in case anyone's curious about what we meant here, this is what we meant here. And one of my favorite things to talk about in this area is the Voting Rights Act. Because the Senate went through and did a rewrite of the Voting Rights Act in 1982, and they were so worried about how it was going to be interpreted and how it was going to be used that they made just this really over-the-top record of all of the things that went into their decisions of exactly how to write this thing and why they did each little thing. And I'm a little bit upset lately because I've read a lot of it, and it's kind of being ignored. It's being ignored because, as a general rule, a lot of the court has moved away from reading these things anymore. But when the people who wrote it give it to you and all agree that this is part of it, this is, I think that is a different thing. And so that was one of the things that it wasn't Sotomayor. Who was it? Always reading my own handwriting is always a bit of a struggle. Because it was Gorsuch who said, talking about the difference, I think it was Gorsuch. Was it Gorsuch? I don't know. About the difference between legislative history and statutory history. Like, just kind of reading what people said, people who were giving speeches, and they particularly said, whoever it was said, ad hominem attacks. The people who were standing up and like, well, that person over, it was Kavanaugh, okay, that person over there is stupid and is a dummy and, whatever. He's like, reading all that stuff really doesn't tell us anything about the law. Yeah, it's probably right. But when they sit down and, kind of create a rider to go along with it that says, hey, if you have any question about what we meant when we wrote this, this is what we meant, that might be a slightly different thing. And so that was kind of what they were saying. There's a slight difference between legislative history and statutory history, and maybe this should be considered. So now that is what Puck says is the counterpoint to that, which is, well, if that's what they meant, why didn't they just say it? And, that's a good question. The question here is why there wasn't an express right of action. Well, why did they say there is an implied right of action? Why didn't you just write it in there? I don't know. I don't have an answer. So, but they're saying, in case you're wondering whether we meant to imply a right of action here, we did. Just the way we did in these other ones. So, I'm not sure. But I just wanted to at least let you know what it was that they were talking about there and why it's such a discussion. Because this was, at one point, this was how we figured out what the legislature meant. We went back and looked at those debates and looked at the speeches and looked at that guy's a big dummy, and that's how we that's how we read these statutes and figured out what they were supposed to mean. And that was, it's kind of come and gone over the years a few times, the kind of legislative history as a popular means of interpretation. But it's become much less popular. I'm kind of making this up. I'm going to say since the 60s, but I might be making that up. I have a book specifically on the history of legislative interpretation and how we've done it over the years. And if I had time, I'd go pull the book out and find the actual timeline. But whatever, just understand that there is a timeline. So I just wanted you guys to understand that concept, that that idea has sort of come and gone a few times, and that's why they were sort of talking about that. And I think it was really interesting. I literally cannot read a thing I wrote here. By 3.5 hours, my handwriting is just... It looks like Arabic. Okay. So, I don't have a ton on this last case because I quite literally cannot read it. Let's go back to the first case, which I really did enjoy and I thought was extremely engaging. If any of you weren't here, do we reference the Federalist Papers? Okay, so the Federalist Papers, I do want to address this real quick because so one of my issues with the Federalists is that when the Federalist Papers were written, there were the Federalists and the Anti-Federalists. There were two groups of people who very much disagreed and were all involved in these decisions. When I think the Federalist Papers are most useful is when we are trying to figure out something that they would have been against, but they concede anyway. If that makes any sense. I think that's when it's most useful. If they only ever liked black coffee holders, and they were like, in the morning, we should at least allow white coffee mugs, then that's good evidence that white coffee mugs were sometimes used. I don't know if that example makes any sense, but I look for things where they wouldn't have, when they're making a point that they really, really strongly believed in and nobody else did, that's when the Federalist Papers, I think, get a little bit less useful. And the Federalists had very strong opinions about, for example, the power of the executive. The Federalists essentially became, in some estimations, monarchists again once the war was over. And when France became a revolutionary democracy like we did, they very much disavowed France, who they'd been very close friends with a couple of years earlier when it was a kingdom, and went back to England that was still a kingdom, and totally disavowed France, who'd helped us win the revolution over France, because they did not like that revolutionary spirit coming in and giving more power to people. So the Federalists were very, if anything, if I were going to say anything, they were closer to kind of a strong centralized executive, let's say. Whether they were totally monarchist or not, different people will say different things. But that's why you take what they say with a grain of salt sometimes. Neither here nor there. And by the way, I didn't always know that. That's something that I've learned more recently, having done a whole lot of reading. Yeah. And that's why you have things like Madison and Hamilton, who were besties when they wrote the Federalist Papers, having this huge split a couple of years later because of, what's his name? Hamilton, what was it? Over the executive, essentially what became the unitary executive theory. Hamilton's belief that the president should have really, really broad executive powers, and Madison being like, that is not what we wrote, and disagreeing over what they had just written together a couple of years earlier, and they stopped being friends over that. So anyway, all right, let's go look at this other case, which I think was just really fascinating, and I hope I can pull a couple of cool things out of it to talk about. If any of you missed it, this was a case about somebody who had been given a capital punishment. He'd been sentenced to capital punishment, and he got 5 IQ tests, which ranged from 72 to 78. But the 72 one, the person who gave him the 72 one said that it had a margin of error of plus or minus 3, which meant that it could be anywhere between 69 and 75, right? Somewhere in there. And the rule, the law, whatever it is, has said that 70 is the cutoff. And so the question was, if it could be 70 or below, does that matter? But the hearing went into far different areas than I expected. And also I was expecting, the way it was kind of put in front of us was that there were going to be 2 people kind of having the same sort of arguing together, and then the gentleman, the guy who's on D row, arguing against them. And it didn't really end up that way. The Solicitor General kind of had a thing somewhere in the middle, and the other 2 were sort of on either sides, and there was a lot of overlap, where I think we ended up with possibly a really workable new test somewhere in the middle that I think would be interesting. Thank you, Oregano. That I think you could sort of feel them building around a potential new test. And I think what I started to hear is that the question was going to be whether it was possible to have a new test or not. Because I think the question was coming down to when a lower court, when a district court judge was either no longer allowed to hear extra evidence. Like, he had gotten IQ tests, they were too high, and so he's not allowed to consider anything else. Or, on the other side, whether he is ever allowed to say, hey, I've seen the IQ tests, I don't need to see anything else. Or a third standard in the middle where he always has to consider both the IQ tests and some other things. And so you kind of saw things on either end of the spectrum in the middle there, but there was also an extreme thing that said, anything over 71 or above, he could no longer look at anything. Compare that with another option that said, if everything was 100 and there was one that was 71 or 70, what would that mean? They kind of talked about those options. Someone had asked while we were in there, actually several of you asked about generally kind of what we were trying to do here, with what the use of capital punishment is. And I've talked about this a couple of times before. In general, there are three really broad theories of criminal punishment. And most of our punishments come from one or some combination of these three theories. And I cannot think of one word, and if somebody could tell me this word, it would be super helpful. What is it when you... There we go. Rehabilitation. That was the word. Sorry, let me write this down so I don't forget. Just sometimes the word just won't come to me. So the three theories are deterrent theory, retributive theory, and rehabilitative theory. Okay? Three main theories of why we punish people for crimes are either to deter them from future crimes, retributive to basically revenge, to get, which has a couple different sub-theories to it, but that's the general overarching theory, is retributive theory, eye for an eye. And the third is rehabilitative, which is to make them better. We do whatever we're doing in the grand scheme of things to make them no longer criminals. And there are 150 different ones, but this is like the three big umbrella theories, or at least the biggest three umbrella theories that... I know revenge isn't right, but there's so much more to it than that, because there's the whole idea of the but it's the fastest word I can think of, retribution. In one way or another, you're paying back society. That's part of that. It is a big umbrella. So there is sort of a thing like, you have taken from society and therefore you need to give back something to society, and so we will take your time. There's all kinds of things under retributive, but part of it is actually rooted in, you can't also take that one out, which is part of it is just, we think you deserve this. That is part of retributive theory. It's one of the things under the umbrella, and there are people who believe that. And so when you look at capital punishment, you're probably not going after rehabilitative, right? Not a lot they can do afterwards. What you're mostly looking at is either deterrence or some version of retributive, in various ways. You're either trying to keep people from doing this bad thing because the punishment is so bad that they won't want to do it, or some sort of retributive theory that you took from us and now you owe something back, and to balance the scales. And so you have to consider, when we're asking what one of the reasons that that we have this cutoff here is that the idea is that a person who is incapable of processing things in a certain way would not be capable of being deterred, because they wouldn't understand necessarily, wouldn't be able to process that this is the punishment for that action, either for some variety of reasons, or that there is no retribution to get from them because, again, they did not know they were doing something bad. So there, it's not that they, in their mind, they really didn't do anything bad. They just, hugged the bunny, George, and don't understand that the bunny, you can't hug the bunny like that. And so there's no retribution because there's nothing to, they didn't take anything for them to give back. And so under those two theories, that's where we're kind of working here. That's the universe that we're sort of working in when we look at things like finding that people are not capable of going through certain kinds of punishment and why we limit these kinds of punishment. And so when you're looking at when punishments shouldn't apply and when they should, a lot of it you have to stop and think whether this is a deterrent-based punishment, a retributive-based punishment, rehabilitative-based punishment, or one of the several others. But it does kind of help you understand what the logic is a little bit. Sorry, yeah, mice and men. Yeah. So this is what they did, because somebody was also asking about the what were they something really important. Come on. Oh shoot! About using IQ as opposed to, say, looking at people with neurodiversity and that kind of thing. And it's not, neurodiversity might be appropriate in some cases, but you have to remember that what they were trying to do when they first did this, and what they're still trying to do, is to figure out who the people are who have committed crimes but would not be deterred, cannot be deterred because they don't understand that they're doing something wrong, and that there is no retribution because they didn't actually take anything, that they don't understand that they've taken something. And so that's where they've used IQ, because they figured that was one of the better ways of figuring that out. And whether someone who whether there are other people who might have a higher IQ but still are not capable of those things is a very good question. And so that is, but I didn't want to say, somebody was talking about neurodiverse people and maybe autistic people, and it might be appropriate if the exact right person came along who had a higher than this IQ and was incapable of being deterred and retribution. So, long way of getting around to that point. I apologize, but I did want to bring that back because there were some very intelligent questions, and I wanted to bring it back. So there are also some questions about sociopathy and psychopathy, and it seems to, I think in that case they don't seem to have the problem with it because under retributive theory, remember, big umbrella for retributive. And retributive does include partially the idea of revenge. And getting revenge against somebody who truly, getting revenge against a tree that fell over because it was old, you can't get revenge against that. Getting revenge against a person who was just trying to hug the bunny, you can't get revenge against that. It's a little bit harder to sell it when someone with sociopathy and psychopathy. And so you have to remember that is a big umbrella. And it's also probably going to be a little more broadly used depending on some of the mindset in the area that we're talking about. It's probably going to be different in different areas of the country. But it is often going to come down to that concept of retributive whatever. So, but I do think that, the idea, keeping that idea in the back of your head, I think will give you some really interesting thoughts as you move forward. The idea of this deterrent, retributive, and rehabilitative ideas, and which punishments do what and when they apply. Thinking about those as you look at news stories and stuff is really interesting because it comes up a lot. Okay. I have a couple of questions for you guys before I start losing the big group. I would like to know, and I have an actual question here, because I haven't quite figured out how to do this, but if I were able to set it up, I know that it's annoying when I am speaking at the exact same time that they are speaking, but I'm trying to answer your questions, and I do apparently get in trouble if I'm quiet for too long. So I have to talk occasionally, or I will get cut off. So I'm trying to figure out a way where I could maybe have the volume drop for a minute while I'm talking, or I can consider pausing for a minute. And my concern with that is that these are already like 2-3 hours long, and I don't want to make them longer. But okay, pause. I'm getting one for pause. So I don't know if I'm gonna do it, but I think I'm overrunning my CPU's running out of power. Okay. Okay. Sometimes I'm still gonna have to do it because I don't want to, but maybe I'll try to do both. Ooh, I'm running out of time to do this because my CPU is getting overrun. Let's see here if I close some of these windows. Okay, so that was one thing. Second thing is that I'm trying to find without being annoying. I'm trying to find ways, because I'm not in the creator rewards program anymore. So I have to find a way. If I want to keep doing this, I have to find a way to get people to either buy things or whatever. But I also feel very annoying asking in the middle of stuff. So I can either put stuff on screen, but I don't know if that's equally annoying. Let me know what you think, and let me know if there's something that you would like. Shirts or mugs or anything. Please let me know, and I can put them up, because that is how I'm going to be able to keep doing this, because this is all I'm doing these days. So, okay. Oh, thank you. Okay, let's see then. Okay, hoodie. Let me know what you want. I have the ones that I have already, but if you want something different, let me know. Okay. And I do think this might be slightly less, because it's not going through as many filters, as many extra things, adding stuff. Okay, so we talked about the 3 different. What is that saying? The 3 different standards that I think they're going to look at. I have a feeling that what they're going to end up doing is either do what you do. Okay, thank you very much. I mean, my take on sovereign citizens. I will get there in a second. So YouTube is actually better because apparently because I'm not on creator rewards anymore here. And Betharoni says, okay, fine with the way it is. All right. Oh, and I got a gift membership. Thank you, Betharoni. Okay, so and then I also have the stack as well. But okay. Is there anything else I wanted to say on that front? And then I'm making these things, but I need to tell you that they exist sometimes. And but again, I hate having to stop and say it. It's not really part of my normal speech. So, and then also my wish list is very helpful because I have a lot of stuff on there that I could use. So, thank you. And I appreciate when people send stuff. All right. So what I think we ended up with, guys, today in this case was one. I think they're going to end up in one of 2 places, which is either that a judge has complete flexibility, basically, to decide anytime they want whether to consider only IQ tests or IQ tests and other stuff. That's one option. Or, alternatively, that a judge is restricted to one or the other. I'm losing my phone. Have I considered teaching? I would love to teach, but I have not done it yet. Oh, and that was the question that... Really, BJ? Where is that? Oh, sovereign citizens. So I think that sovereign citizens... are probably rooted in some stuff that some things that are understood and that's cool. But I think that there's some stuff that they have missed. And I usually, when we talk, I'm usually able to get them. We talk about a few things. It's like, oh, okay, all right, and it, or they just think I'm crazy and lying, which is also fine. You know, can't please everybody, right? And I know I'm getting skippy because my for some reason my CPU is running out of space. All right, tell you what, I'm gonna have to wrap up because my yeah, I'm